mentioning.
May I be permitted, my lord, that item number, not GA number 4 of 24 was disposed of previously, but on that occasion,
GA number 4 in commercial matter?
No, in PLA. My lord, on the previous day, your lordship was pleased to direct me to complete the report.
PLA 401.
PLA 4 of 2000.
Which item you are referring to?
That is PLA 184 of 2011.
Which item number?
No, that is I am mentioning, my lord.
Oh.
30th January has been fixed for filing report. But in the meantime, my client, who is old lady, has fallen ill and could not complete that commission.
Let it come.
My lord, now he has almost recovered. But my only prayer is, my lord, to give me another 15 days time only.
All right, let it come in the report. I will extend time.
The order.
Let it come in the list.
Yes, my lord.
To be mentioned next Tuesday to have next Thursday দিয়ে দাও 31st আছে না 30th. I will extend time.
Much obliged, your lordship.
To mention it on Thursday. Come on Thursday, mention it, I will extend.
Origin side commercial division, item number 1 and 2.
Please, your lordship.
Before my learned friend address, may I just take this liberty? Kindly see the last order, my lord, of 14th of January 2025, passed by my lord.
Copies of deed of mortgage as well as title deed
Yes,
will be produced on the returnable date.
this is one. And number two, my lord, if it comments to my lord observe that the copies of the report may be handed over to the learned councils. Now, my lord, what we were given with all humility is a one-page document. Because I appear, my lord, for the office.
Let it come before this court.
No, it came before the court. I am on the first paragraph now of the order.
Is it filed?
Yes, no. First paragraph. Kindly see the first paragraph.
First paragraph of what?
Of my lord's order. Report of the learned register, my lord, along with the report are perused. Copies of the reports may be handed over to the learned councils. Now, here, my lord, the entire I appear for the official degree. I don't have. Now, the report consists of, my lord, if the first report consists of 4 flags and the second report consists of 6 flags.
The report is given, annexures are not given.
Yes. If that comments to my lord is because
you are concerned with the report only.
Very well. If that is so, just to point it out to my lord.
Report is compilation of all the departmental notes.
Very well. I don't appear for a private party. I just appear for our records if it is necessary to keep it. Otherwise, it's a court's record.
You can inspect it, in fact.
That liberty was not given. Kindly.
All right. I am giving you order.
Yes. And the second part, now, my lord, Mr. Bose may address, my lord, that they are to submit this
supplementary affidavit.
That has
We have
just a minute. Right to likhun to. Which report you have got?
I have got copies of both the report portion.
2nd January 25 and
2nd January 25 and also 9th
December.
We may be also supplied with the document.
Copies of the report of the learned register dated 2nd January 2025 as well as 9 December 2024 was learned counsel. That is, you are not given.
I have not been given.
Have you got it? Supposed to be given to the council, learned councils. Were not given to the other councils except to Mr. Rai, the learned counsel appearing for the official liquidator. Full stop. Copies of this report may be handed over to the learned counsels for the parties appearing before this court. The full report may be inspected. The report along with the annexures of the report may be inspected. Full stop. Yes, now next part.
Now, my lord, immediately I am handing over the affidavits along with 2 certified copies. Certified copies of the mortgage deed as well as the sale deed. It's same. Oh, no. Certified copies. Yes. Oh, photocopies.
Photocopies.
Photocopy of the certified. Yes.
Thank you.
So official liquidator is to obtain the certified copy of these deeds.
Certified copy is already there with our client.
With your client.
Yes. Your lordship directed copies, 2 copies of the certified copies to be filed.
Better certified copy maybe my lord filed.
That
That kind of authenticity.
Why
can
the
be-
certified copy shall be filed? This will be collected by the official liquidator. It is duty of the High Court or official liquidator rather.
That can be done. That will take time.
If it is lost from the custody of the High Court or from the custody of the official liquidator, it's their duty.
Yes, they can do it.
Supplementary affidavit. Next part, next paragraph করে লিখবেন. Supplementary affidavit is filed in compliance with the order dated 14 January 2025. Copy served.
yes, I'll serve the copy.
Copy along with the annexure is served. Now you go through it. Mr. Rai, you go through these documents.
Yes, ma'am,
You have to collect the certified copies.
apparently, both the documents seems to be the same date.
Yes. Same date the sale and the mortgage took place on the same day.
You go through these and come back on the next day.
Gentleman was short of funds. He purchased it and on the same date he had mortgage deed proper.
For obtaining money.
Yes, this is not in dispute. These are not these
No.
these
Today,
are not in
Let the
dispute.
official liquidator be apprised of these things.
Unless we go through a question of disputing the same.
Whether it is to be disputed or not, that is the issue also.
First of all, you obtain certified copy, authenticity will be proved thereafter. And
Sir,
then
kindly give me a reasonable time, my lord, we'll come back.
Fix the matter on 17 March for further hearing.
17th March.
certified copy pa kotha time lagbe.
February is very difficult for me.
5-10 minutes for this one, kindly, because otherwise this is
February, you looking for February, a date in February.
Yes, Lord, kindly.
Date দেখো তো. Twentieth February is okay. 20th February. No, original deed, so far I understand, original deed can never be returned.
No.
Even there is an order of liquidation of mortgage, redemption of mortgage. The
Now
original deed, if the order is passed, then the original deed shall be substituted by a certified copy that you have to give because on redemption of mortgage, and that would be valid discharge. Only to record that originals are missing.
That will be treated as original.
after my lord's orders, yes. That will.
My Lord has heard the matter. We have.
Yes, thing is that even if the order is passed, I'm not saying anything. If the order is passed, then what to do?
No, if the order is passed for return of the original title deeds, now it appears, my lord, it cannot be executed.
Cannot be executed.
So, my lord, maybe please not to pass an order which may not be executed.
Right.
Now, as has fallen, my lord, we have maybe filed the short notes of submissions, my lord, we have prepared, if it is allowed.
Come on the next day, go
Or-
through it, come on the next day.
Now, we submitted, my lord, that the practical and the legal and the equitable solution is to apply for a certified copy. And we did not have copies of the title deeds at that point of time, but copies of the mortgage deed was, I think, annexed in one of the parties' affidavits, probably in GA number 1.
Now this will go through. This
Yes.
will be
Now, if we can trace it and if we will take instructions, if this is there, then obviously we'll apply for certified copy. And hopefully certified copy is given, my lord, it will be treated as an original by
then necessary order will be passed.
absolutely one way or the other. Deeply obliged, my lord, for this.
Item number 3, Commercial Division.
Item number 3, I appear for the defendant. I have taken out an application being GA number 4, wherein, my lord, directions were there to exchange affidavits.
My lord, I appear for the respondent, my lord. I have
Exchange of
received,
affidavit is complete.
yes, my lord. I received the reply only yesterday evening, my lord. I am prepared with my opposition also. Lordship kindly takes it on record and fixes it any day, and Lordship disposes.
What
it.
you are filing today?
My lord, my opposition, my lord, to his application.
My reply.
Affidavit in opposition as well as affidavit in reply are filed today. Let the same be kept in record. This is an application for
My lord, this is an application whereby we have sought a direction that necessary orders be passed for dismissing the suit on the ground that there has been several directions that has been passed by my lords, and wherein directions were given for inspection and discovery. The plaintiff has not taken any steps for inspection and discovery. On the contrary, they can come up at the very belated
under order 12.
Yes, at the very belated stage, they come up with a judge's brief of document, wherein the defendant has already offered them inspection 2 times. They have never taken the inspection, and they never offered me any inspection. Now they have prepared a judge's brief of documents without including the documents that the defendant has relied upon.
Where are the previous orders?
Yes, my lord. My lord,
Have you annexed here with?
Yes, yes. My lord, kindly takes up page number 22 of the application.
Yes, 22 onwards.
Yes, 22 onwards, 22, 24, 25, 26, and then 28. Several directions.
All right, go through the reply. Come on the next set.
Very well.
Let the matter appear in the list on 19 February.
Grateful, my
Item number 4,
Your Lordship,
Pursuant to my lord's last direction, my lord, statement of truth and affidavit has been filed.
Your Lordship, I'm appearing on behalf of the defendants. I'm being led by Mr. Shantanu Bose in this matter. Kindly grant us 3 to 4 weeks time in order to file the affidavit and the statement
2
of
weeks.
Grateful.
truth. Grateful, Your Lordship.
Statement কোথায় কি দিয়েছে দেখি? Statement of truth. Affidavit under order 11 rule 6 as well as under order 11 rule 1 of CPC are filed today on behalf of the plaintiff. An accommodation is sought for by the learned counsel for the defendant to file the same. Accommodation is allowed. Steps shall be taken and affidavit shall be filed along with statement of truth on or before the returnable date. Let the matter appear in the list on 24th February.
Obliged, Your Lordship.
item number 5,
Here for the plaintiff, but my witness was already in the box. My lord, he's here.
Where is your witness?
I'm appearing for the defendant. Witness. He's here, man.
You came that day for certain prayer.
we started the matter, but it was objected by the other side.
Mention it. Mention the matter. I will include it in the list. Then I will hear you.
Some other matter, my lord. Not this.
Yes.
I had, my lord, already put, like, he may be, my lord, permitted to be in the box. I had, my lord, put 5
Come here.
questions to him.
Cross-examination.
Chief. I had put 5 questions to him, my lord. He is the valuer.
Yes, I understand.
Yes. But on the last occasion, time was taken, my lord, because he has a 130-page report. They wanted to produce the report. But today, my lord, it can.
সর্বজিৎ দত্ত DATTA
I am showing you a document appearing at page 122 of your evidence on affidavit. Can you tell this honorable court what this document is?
Can I have the copy?
My lord, before the witness answers, may I make a preliminary objection? In the evidence, my lord, there are two documents, AA and BB, and the plaintiff seeks to mark these as exhibits. Now, my lord, I am taking the objection because initially this was a non-commercial suit. It was subsequently transferred to the commercial division, my lord, and the regular, my lord, other aspects had to be complied with, including filing of list of documents. Now, my lord, Commercial Courts Act, my lord, made certain amendments to the CPC, my lord. Under such amendment, my lord, kindly considers Order 11, Rule 1, Sub-Rule 5, my lord, which says that the plaintiff shall not be allowed to rely on documents which were in the plaintiff's power, possession, control, or custody and not disclosed along with the plaint or with the extended period set out above, save and except by leave of court.
This manner, I cannot hear it. I cannot decide on the matter.
So, my lord, leave of court has to be obtained. If my lord allows leave, but there has to be some.
This is a transferred suit, my lord. And then the
No, if some document was not produced earlier, and if so far that you have to set out a case.
I will, my lord, indicate, my lord, this valuation report.
I cannot decide the matter this way. I have to know whether this matter is a fresh one. It is this document is a fresh one. This document is subsequent.
Fresh one, my lord.
So you have to file application.
No, my lord. This document will.
All right, produce this document on objection.
Yes, let it be exhibited on objection. What is this document?
This document is my valuation report prepared under the instruction of the plaintiff.
Because if this document is to be exhibited and it is a subsequent document, definitely leave is to be taken.
My lord, one is 2001 document. The suit is of 2004. The first document is a document of 2001. And my lord, the second document, my
in that case, it is going with on objection. You can file
record that it is subject to objection under Order 11, Sub-Rule 5, my lord. And my lord may decide the objection later at the final disposal.
No, that cannot be decided at that time.
My lord, then I would submit, my lord, because
let this go with the objection for expunging your file application.
Yes.
For at least objection under that rule, my lord.
Yes, objection. It will go on objection.
Very well.
This document was, my lord, it's a 2024 document because he valued the property recently. So, my lord, obviously at the time of.
All right, on objection.
Yes. Do you find any signature appearing at this document?
Yes.
Just a minute.
Yes, the signature is that of my signature appearing in page 122 to 134. All the pages of my 122 to 132.
Because Mr. Mukherjee, a subsequent document that cannot be disclosed earlier. For example, the report of the partition commissioner.
My lord, that is why we make an application for making additional disclosure, my lord. We first disclose, then we put the document.
It will go with file application.
My lord, if he may be permitted to encircle one of the signatures on one page.
Yes. Is it the original?
This is the report, my lord. Yes.
Report is original. Your signature is original or copy? Let me see it. Where is the original report?
The original is here, my lord.
The original should be produced. এটা marking হবে না দেখি original report. Yes, the original will go.
Yes.
Why the report will be marked? Copy will be marked.
Not the copy, my lord.
Yes, এটাকে mark করুন। ওটা কেটে দাও, mark এটা হবে। Encircle your signatures. And how many signatures are there?
In all pages,
all the pages, 11 pages, my lord.
All the signatures we mark collectively as exhibit Q by 1.
But the document also be marked as an exhibit, my lord. Yes.
Yes.
Are the contents
Q with objection, Q by 1, of course, there will be no objection on signature.
are the contents of this document true and correct?
The contents of the documents are true and correct.
On what basis have you prepared this report appearing at page 122?
This report is prepared on the basis of the inspection, the reference deed that has been attached with the report, and the value has been assorted accordingly.
I'm showing you a document appearing at page 6 of your evidence on affidavit. Can you tell this honorable court what this document is? What is it?
This is the certified copy of date number 2035 of 2003, which is one of the reference for preparing my report.
May also this be marked as an exhibit?
This is a much prior
Objection.
document of 2001 with objection.
This is, my lord, a part of the report. My lord, this is part of his evidence.
Mr. Mukherjee, I am
It's a certified
noting your
copy.
objection.
My lord,
If
that
you
is
want to expunge this from record, file application.
Yes.
Exhibit. With objection.
I am showing. I'm showing you a document appearing at page 41 of your evidence in affidavit. Can you tell this honorable court what this document is? 42.
This is another certified copy of the deed procured on 03/02/2024 for the deed number 1902-10731 of 2009. 03/02/2024. Acha, 1902. This is the reference deed referred by me for preparing the rental value as on the period of 2009.
I'm showing you another document appearing at page 76 of your evidence in affidavit. Can you tell this honorable court what this document is?
This is another certified copy of the deed procured on 8th of February 2024, and the deed number is 1766 of 2017.
May this also be marked as
This is also a reference produced for referred for valuation.
Yes.
Reference deed.
Objection.
This is also a reference deed.
mark hobe, mark.
আগেরটা মার্ক হবে আর হবে তো
With objection. Well, all these
with objection, yes. তাহলে আগেরটা এস হবে
Yes, yes.
এক সেকেন্ড এখানটাতে আপনারা যেটা দিয়েছিলেন দুটো ছিল দুটো কি একসাথে
কোনটা আর দেখো
প্রথম টিটটা যেটা করেছেন পরের টিটটাও এক্সিবিট হবে সবকটা টিট উইথ অবজেকশন
এর সাথে ডেস ছিল
এটা আর হয়েছে এটা আর হয়ে গেছে
এই দুটো একসাথে দিয়েছিলেন
সমস্যা
1017
এটার সাথে স্যার ওই দেখে দিয়ে চলেছিল
নাম্বারটা দেখি
এটা হচ্ছে 109210 19021071 এটা হচ্ছে
কি কোনটা
উইথ অবজেকশন এটা সবগুলো উইথ অবজেকশন All documents have to go with objection. Mention the number of the deed against the exhibit.
1766/2017 এটা হচ্ছে exhibit TT with objection. কটা deed গেছে একটু deed
কটা গেছে? তিনটে গেছে ভাই। তিনটে গেছে।
Yes. এরপরটা ঠিক। ওটা হয়ে গেছে।
I'm showing you a document appearing at page 62 of your evidence in affidavit. Can you tell this honorable court what this document is?
This is another certified copy of the reference date procured on 7th of February 2024. The deed number is 02547 of the year 2013. This was referred to prepare the rental value as on 2013.
Well, may this also be marked as exhibit?
On objection.
On objection.
You with objection.
This is you.
Okay. What was the purpose for you to procure these 4 deeds?
I have procured the deed as a reference for justifying my rental value for the different periods, starting from 2003 to 2017.
Original report. Original report.
On exhibit Q. Finally takes page 123, the exhibit Q, internal page 2, appearing at page 123 of your evidence in affidavit, and come to serial number 4. Is serial number 4. The question is the purpose for which valuation is made. Are the contents against this serial number true and correct?
So there is one typographical error in this point. It should be read as to ascertain the rental value stroke fair market rent of the property for the period of 1/12/2003 to 24/5/2017 instead of 1/5/2017.
My chief may be concluded.
Ross.
ask a few questions and I'll
Ask a couple of questions.
Yes, madam. Mr. Dotto, na?
Dotto.
Mr. Dotto, who approached you for preparing this report?
I was approached by one of the representative of the claimant, Mr. Pratap Kumar Mondal.
Were you adequate?
Representative of whom?
Of the claimant.
Claimant means?
Rigdima,
Namely, Rigma Dirappa
Rigma Dirappa.
Investments Private Limited.
Did you receive adequate remuneration for preparing this report?
I have received my the professional fees.
Was there any negotiation of your professional fees before you were engaged in preparing this report?
No.
So the plaintiff paid whatever you had quoted as your professional fees.
Yes.
Am I correct?
Yes.
My lord, I'll ask the rest of the questions.
Is PW2.
PW3, my lord.
PW3 is examined in chief in full and partly cross-examined. Further cross-examination is deferred to 19 February.
Grateful to my lord.
Item number 6.
ফাইলটা কোথায়?
অর্ডারের জন্য করলাম দেখলাম আমার এক্সট্রা দরকার আবার হিয়ারিং তো একটা জিনিস একটা কাজ করতে পারি ওরা দিতে পারে আমি প্রিন্ট আউট থেকে পারে একটা প্রিন্ট আউট নিয়ে আসছি সেটাও রাখতে পারি ওদের একটু রুলস আছে
Yes.
This one, I am paid for the different number 1.
Who is the plaintiff?
Aurik Banerjee was appearing, my lord. He was just now, he was here only.
He was talking to you.
Yes, yes.
And when the matter is called, he escaped.
Aurik. Why is Aurik dark now?
Witness is present or not?
No, he has told me that the witness is not present. He is not in a position to depose. So he would be praying for an adjournment. That's what he said to me.
Are you plaintiff? No, he is not plaintiff. Mr. Banerjee, Aurik Banerjee. Witness, plaintiff witness is...
Yes, yes.
Just now you're here. And when the matter is called, you run away. Witness is there.
No, witness could not come. He's
When
suffering from
when
medical.
witness will
But
come?
we will kindly keep it any day after 5th of February.
After?
5th of February, any day. Because we're very sorry when the matter was called. He was not there. Yes.
20th February.
Yes. 20th.
কি বললাম? Plaintiff's witness is not present. And Mr. Banerjee, the learned counsel for the plaintiff, seeks for an accommodation. Adjourned to 20th February for witness action. 20 is okay?
20th is okay. Yes.
But we would be appeared for different number 3. I'm sorry. Not different number 1, but different number 3. Yes.
Different number 1. He's mistaken. Axis Bank. He's appearing for Axis Bank.
Your Axis Bank?
Axis Bank, yes.
Different number 1.
Give us sleep.
Give it. I'm sorry.
Item number 7.
Where is the witness? Yes.
Just fixed for re-examination of the witness.
Have you filed application any?
Lordship, it was allowed on the last occasion.
Who is your other side?
Here.
You speak English?
No.
কি করছেন across?
Soroshish Dashgupta.
Yes, my lord. Junior
করে নিয়েছি ঠিক আছে
Your re-examination.
No, re-examination.
Cross-examination টা বাদ দাও।
Cross-examination টা চাইছি।
Re-examination of PW1.
Yes, sir. I'll just straight away take to the questions of the cross-examination for which I seek the clarification. Cross-examination. Question 71. 71. Mr. Bengani, kindly come to question 279 of the cross-examination and kindly read the answer given by you.
আপনি বলেছেন, have you mentioned anywhere in your claim that have saved some money from being spent while taking over the job of production of film graffiti? আপনি কি কোথাও উল্লেখ করেছেন যে আপনার ক্লেমটি কোথাও উল্লেখ করেছেন যে আপনি
না আমি জাস্ট আনসারটা পড়তে বলেছি
কোশ্চেনটা না বললে আনসার আপনি কি কোথাও উল্লেখ আপনার প্লেনটি কোথাও উল্লেখ করেছেন যে আপনি কিছু টাকা খরচ হওয়ার থেকে সরিয়ে রেখেছেন, খরচ হয়নি সরিয়ে রেখেছিলেন যখন আপনি হেরাফেরি ছবির পোস্ট প্রোডাকশনের কাজ করছিলেন? আপনি উত্তর দিয়েছিলেন
না না
ইন দ্য প্লেন ইট ইজ নট রিটেন এনিওয়্যার। প্লেনটি এটা কোথাও
Only to produce some documents for limited purpose.
when I came to know that they would not make any payment, কিন্তু যখন আমি জানতে পারলাম যে তারা কোনো রকম পারিশ্রমিক দেবে না, then I sent them a notice, তখন আমি তাদেরকে একটা নোটিশ পাঠিয়েছিলাম to my learned advocate সব্যসাচী সেন। আমার
সত্যি আমি
এটা আপনি
বলেছি এটাই বলেছি আমি।
Mr. Bengani, have you produced such letter before this honorable court?
হ্যাঁ আমি কোর্টে আমি অলরেডি লেটার দিয়েছি ওনাকে।
I have produced this letter. আপনি কি কোর্টের এখানে জমা করেছেন, এভিডেন্সে জমা করেছেন?
এভিডেন্সে জমা করেছিলাম না।
Yes, I have submitted this letter.
I'm showing you a document, letter dated 20th December 2017. Kindly see whether this is that document.
এইটা কি সেই চিঠিটা?
হ্যাঁ সব্যসাচী সেনের এই চিঠিটা আমি ডিমান্ড নোটিশটা দিয়েছিলাম। হ্যাঁ না না ঠিক আছে স্যার।
It is at pages 13 to 16 of the judge's brief of documents.
Mark it. Letter along with the postal receipt
As also the acknowledgement due receipts.
and acknowledgement due card are collectively marked as.
May I just put the questions before it is marked as an exhibit, whether it's been carried out as instruction? Kindly tell this honorable court at whose instructions this letter was issued by Mr. Shobhushachi Sen, advocate.
তার নির্দেশে অ্যাডভোকেট সব্যসাচী সেন লেটারটা
আমি বলেছিলাম ওনাকে চিঠি দিতে।
Have your instructions been carried out in the
হ্যাঁ হ্যাঁ আমি পড়েছি এটা সেভাবে। হ্যাঁ yes yes
I have perused the letter. It is correctly written as per my instruction.
right sir.
How was the letter sent?
By speed post.
let him complete first.
Okay.
How was the,
ঠিক আছে ঠিক আছে।
how was the letter sent to the addressee?
করে পাঠানো হয়েছে
স্পিড পোস্টে।
Was the letter delivered by Geeta Dubey?
হ্যাঁ।
Have you disclosed the consignment track report?
দিয়েছি।
Now the document we marked.
Collectively with postal receipt and acknowledgement due.
Lordship may be marked with objection because in my affidavit of admission and denial, I have denied the contents of the document.
It's not content. If the document is produced.
Yes, Your Lordship. May it be recorded
On
as-
objection.
Yes.
Collectively, it will be marked collectively.
Kindly come to question 264 of the cross-examination.
পড়ে নিয়েছি I am suggesting to you বুঝতে পেরেছেন ঠিক আছে
Have you disclosed any prior trade license as referred to in question 264 and in your answer to question 492?
আমি একটা ট্রেড লাইসেন্স জমা দিয়েছিলাম আগে কিন্তু উনি বাবার
Yes, I have submitted a prior trade license.
2013 ট্রেড লাইসেন্স চেয়েছিলেন সেটা আমি তখন জমা দিইনি
I asked for the trade license of 2013, but I could not submit it at that point of time.
আজকে আমি নিয়ে এসেছি
I have got this license today with me.
Witness produces the trade license. I'm sorry, the question should be 491, not 492.
This is the original trade license.
Yes, original trade license.
If the witness produces the original trade license pertaining to the year 2013.
Witness producing
May I just show it pertaining to the year 2000?
Actually, question.
Be marked as an exhibit.
Lordship made go down as objected.
Objected. Non-objection.
Kindly come to question 503 of your cross-examination. Kindly read.
I suggest to you, আপনি আপনাকে সাজেশন দিয়েছিলেন যে the defendant is entitled to recover a sum of rupees 4,11,000. আপনি বলছেন I receive
এটা করতে তো this
basically the project inspector undo every wrong thing said by the this is the competitive
Certain documents. He said certain documents.
Let me ask the question, then my learned friend, let him take his objection. Lordship, I am only entitled to re-examine
Certain documents only, not for other purpose.
Lordship, if an answer has been given which requires an explanation, only that I am on. Nothing more than that.
Yes.
Kindly explain why you say you disagree with this.
You have to produce certain documents, not explanation. That was not permission was not given for that.
Lordship, I will produce the document also. Kindly let
Produce the document then.
Yes.
Just produce this document. Any other document to produce?
No, this is the last set of 3-4 questions. That's it. I'll close the re-exam.
But not to fill up the lacuna. That cannot be allowed.
Lordship, it's not a lacuna. He has answered. Lordship will kindly take question 503 once. He says that he disagrees that the defendant has a claim. I'm only asking him to explain why he says this.
All right. No, this can be gone. When the claim is denied, related to the claim.
It's related to the claim.
On objection. On objection. Yes.
Kindly answer.
কেন এটা যেটা ডিমান্ড করেছে এটা পুরো ফলস ডিমান্ড আছে কোনো এর কোনো
That is in the written statement. Why is something?
হ্যাঁ it is আর এর জন্য একটা চিঠি অলরেডি আমরা দিয়েছি সেটা আমাদের রিটেন স্টেটমেন্ট দেওয়া আছে এখানে এই ব্যাপারে রিটেন স্টেটমেন্ট দেওয়া আছে আমাদের সেটাই আমার সত্যি
I conclude the re-examination.
Re-examination is complete. PW1.
Yes, madam.
PW1 is re-examined in full and is discharged. Would you produce any other witness?
Lordship will kindly give me a day's time. I will take instructions and I'll.
Keeping it for further witness action. Fixed 20th February for further witness action.
Lordship, I believe that original was handed over Xerox copy.
Very good. Original will be taken back in the usual way. You know how to do it?
Yes, ma'am. I'll serve a copy. Just one document.
That's why on objection. It is gone with.
Lordship, maybe make a copy from the original.
You will take back the original on giving an authenticated copy as provided in CPC.
And a copy to
Copy to, of course.
I'm grateful, Your Lordship.
Or you do one thing.
Yes, my lord.
Surya. You file an application before this court so that I will pass direction to Calcutta Municipal Corporation to provide an authenticated copy of this document. That will be kept in record and this will be written. But problem is that this is already marked.
Very well, Your Lordship. We'll get a number.
So that can be done. Because I can give it to you, but this is marked document.
Very well.
File with the application. Next day, file an application. Possibly, you will not oppose it.
We'll file the application. Great.
Item number 8.
For the plaintiff, Malad, I am being led by Mr. Onjan Ray Malad. I have been informed that the witness could not appear before this court due to his medical emergency. Malad.
On prayer of the learned counsel for plaintiff. Plaintiff witness action is adjourned to 3rd March.
Yes. Let us sleep down. Regular list. Item number 1. I appear for the petition.
What is GA3?
3 means there was an application filed for general citation and special citations. That was disposed of. But the way is showing the matter is itself disposed of. That's why I brought it in to be mentioned for proper clarification. Last order was on 5th of April 2023.
No, prayer A and B were allowed.
Prayer A and B allowed.
The matter should not be disposed of.
No, it's not disposed of. It's pending, my lord.
So how can you say it's disposed of?
Well, it is showing as disposed of.
No, it should not be disposed
in
of.
the key status, my lord, it is showing as disposed of. That is to be rectified. Well, all other formalities are duly complied with. Already a report is there.
Report of the learned register dated 8/1/25 be kept in record. Full stop. Pursuant to order dated 5/4/23, general and special citations were issued. It is also in the report that there is no caveat. Full stop. Let the will be proved in solemn form. The matter will appear in the list for witness action on date below. Mm-hmm. 20 is okay, 20th February? 20th February. Just a minute. Application now. Will is here? Will is here?
Will is there. Translated copy is also there.
Bengali will.
Yes, my lord.
All right.
20th February.
Item number 2, 3, and 5.
I'm for the defendant. And for the petitioner and IAG number 3.
There are 3 applications. First application is by the plaintiff.
Which is GA3? GA3 by defendant.
Yes.
Defendant number?
Number 1, 2, and 3.
1, 2, and 3.
GA2 is by plaintiff. GA2 is by plaintiff. Enjoying an interim order. GA3 is by the defendant seeking for dismissal of the suit.
Yeah.
And GA4 is again the application of the plaintiff seeking extension of time to file.
3 and 5. 2, 3, and 5.
Item 3 and 5.
Item 2, 3, and 5.
Yes.
2 is your application.
GA2 is my application.
That is plaintiff's application.
For interim reliefs, I am enjoying an interim order. Affidavits are GA2. No, I am saying GA2.
No. GA2 of 24.
Yes.
Is an application by plaintiff. Interim application.
Enjoying
initially that was granted and continuing.
And the affidavits are complete.
So for the timing, we have no so much headache with this one.
Right. The next
so far as 4 is concerned, GA4 of 24.
GA4 is my learned friend's application being the defendant in the suit seeking dismissal of the suit. Sorry, GA3. And
GA3, yes.
Yes, GA3 is his application for seeking dismissal of the suit on the ground of non-service of writ of summons. And GA4 is my application again, the plaintiff's application for extension of time to lodge the writ of summons.
Okay, so 3 and 4 should be taken up together.
Be taken up together since it's my demurrer, my learned friend's demurrer. Let him address.
Goes to the root of the suit.
Yes. And I will.
এইটাকে নিয়ে নাও temporary
Later on, I will
injunction
make a
দরকার
prayer
নেই।
for extension of the interim order, but let my learned friend begin his demurrer application.
Dismissal of suit.
My affidavit is fine.
Affidavit in reply in GA 3 of 24 be kept in record. Yes.
May I move my application? To state at the outset, my lord, there's a 12-year delay in the lodging of the writ of summons. I just take my lord to each of my documents. My lord comes
First, come to your pleading.
Yes, certainly, my lord. Which page, my lord?
Where is your pleading on this issue?
On the dismissal of the suit, my lord.
Yes, that writ of summons was not properly served. There must be a pleading.
Yes, certainly, my lord. My lord.
Para 12.
Yes. We received a report from the sheriff's department indicating that writ of summons, as on the date of filing the application, or just prior that, hadn't been lodged by the plaintiffs. Can we come to page number 70 and 71? That's where I'm going to find the cell that I'm on page number 70, the admission of record wrote to the Deputy Sheriff High Court. This is kindly request to furnish me the admission report of the funds above being capital. The report on whether writ of summons has at all been lodged with your department. And my lord, page number 71. My lord, I place. It appears from the record of this office that the writ of summons in connection with the above suit has not been lodged in this office till date. So, my lord,
let a report be called for from the deputy sheriff. So this is admitted fact, Mr. Ghosh.
Fact, it was not lodged. I have given reasons of that in my.
That will come later on.
Yes, but it is an admitted fact. There is not required to call for it.
Yes. So writ of a very simple case, writ of summons not lodged. So you are seeking for dismissal of the suit.
Yes.
This much. This is your point.
Very simple. Two judgment.
Are you relying on any judgment?
Two judgment.
Yes.
The first judgment is reported in 1993 SCC Online Cal 129. Alternatively, 1994 Volume 2 Calcutta High Court of 160. State Bank of India versus Current Appliances Private Limited and others. 1994 2 CH.
Show him.
161. The judgment of the learned single judge of the court versus Order. And the other judgment I am relying on, my lord. Can I take my lord through which judgment or should I give both judgments right now? Paragraph 13 on this when the material observations on the law. Begin. May I please, madam? Like 18, 19, 20, 21, 22. That's where so it's very clearly explained.
Yes, that is in para 19.
General part, and I'm using this judgment also to counter what has been stated in the counter blast application, where they seek condemnation of a delay of 12 years for lodgement of the writ of summons. Because I very humbly say, does Lodganath Rai here, in his inevitable style manner, rules that the time.
Yes, I have seen that. Para 24 is also relevant.
Yes.
Is the conclusion. Next judgment.
Next judgment, my lord, is a judgment reported in 2007, SCC Online, Calcutta 690. Alternatively, 2009, Volume 2, Calcutta Law Times, page 59. Alternatively, 2009, Volume 3.
All right, let me have it.
Oh, fine. I apologize. Hairu Ratan Patricia and others, that's International Club. Here also, my lord, again, similar facts scenario. One party files an application for dismissal of the suit, another party files an application for extension of time to lodge it. Paragraph 12, 13, 14, my lord, the basic facts are found. Paragraph 14, the petition complains that both steps have been taken. Serves the writ of summons indicates the institution is not taken to place clarification. Then, my lord, 19, 26, 28, 56 to 59, and 70. Paragraph 57, my lord, her lordship, Justice Indira Banerjee, relies on the judgment of Justice Lodganath Rai in his previous slide. As my lord see, paragraph 57. Similar.
Yes, I'll go through it.
Yes, sir.
Mr. Ghosh.
But
Where is your objection? You. Let me hear first. What is your objection?
Yes, kindly. That's what I'm saying. But kindly come to the affidavit in opposition, page 5.
Page 5, yes.
Starting from my lord H Roman 3. I've given details reasons for that. Kindly see Roman 3. As would appear from the plain, filed in said suit. Same was verified and affirmed by one Anand Kumar Dhanuka, who was one of the directors of the plaintiff company. The said Mr. Dhanuka was authorized by the board of directors to said suit. In this regard, an extract of board resolution the plaintiff basis services was signed by Hitesh Kumar Agarwal is annexed. Therefore, sir, Mr. Dhanuka is to look after the litigation of the plaintiff in such process. Mr. Dhanuka was assisted by one Badri Prasad Agarwal. Immediately after institution of the suit, the plaintiff has filed an application being IAGA number 1929 of 2012, praying for reliefs in the nature of injunction and appointment of receiver. Then, in such application by an order dated 27th August 2012, this Honorable Court was pleased to record the undertaking assurance given by the learned advocate for the defendant. The parties were directed to exchange affidavits. Thereafter, affidavits were exchanged by and within the parties hearing in respect of the said application. Subsequently, the said application was dismissed. Now, Roman 7 is very important. The deponent has come to know from the erstwhile advocate on record that during the course of hearing of the said application, a copy of the plaint was in fact handed over to the defendant's advocate on record in court. Then, thus the defendants were well aware of the contents of the plaint filed in the suit. However, it subsequently transpired that although the writ of summons was filed on time with the plaint, but the same was not lodged in respect of the above suit for service of the same upon the defendant's hearing. Such omission is not deliberate on part of the plaintiff. The plaintiff does not stand to gain from such omission. Plaintiff has already paid court fees of the tune of 60,000 and also incurred substantial litigation expense. Plaintiff has initially engaged Mr. Sachin Sach as its advocate who instituted the suit. To the best of knowledge of the deponent hearing, the plaintiff never received any advice with regard to lodging of the writ of summons. In fact, there was no reason on part of the plaintiff to not lodge.
Rather, ignorance of law you are pleading.
No, so I have to be dependent on my advocate. Then
advocate did not advise you.
Yes, and then had the plaintiff
Owing to lack of information.
Had the plaintiff known of such legal requirement, the plaintiff would have taken all steps required for lodging writ of summons. Owing to lack of such information or advice, the plaintiff could not take steps. Dhanuka wasn't able to look after the instant litigation for long since suffered from cancer. In fact, the aforesaid Mr. Dhanuka resigned as a director of the plaintiff company on 2023. In this regard, copy of the resignation letter. Badri Prasad Agarwal, who used to look after the litigation of the plaintiff company, after Dhanuka died on December 17. In this regard, copy of the
Mr. Ghosh, you have to reply. When two judgments are cited, you have to reply on 2 points.
I will. But let me just first find my case on factual basis. I have to give explanation. All judgments that I will cite in support of my contention all say you have to make out some kind of a justification. Upon death of Badri Prasad Agarwal, his son Sushant Kumar Agarwal started looking after. Although the aforesaid Sushant Kumar Agarwal was aware of the pendency of the suit, said Mr. Agarwal was unaware that the writ of summons in the suit has not been lodged. Then defendant number 3 is a Platinum Association. Defendant number 1 or 2 are office bearers. Recently, the defendants had illegally taken possession of the properties.
Which paragraph?
Paragraph Roman 18 at page 8. Then paragraph 19, very important. Under the aforesaid circumstances, in about July 24, the plaintiff filed an application being IGA number 2. That is the interim application that I filed before the Honorable Court seeking interior protective order. Such application was filed by the plaintiff's present advocate on record after obtaining change from the plaintiff's previous advocate on record on 18 July 24. This is change of advocate happened in July. Then it is necessary to state that since no progress was made in the suit the last 12 years.
Para 20.
Para 20. Now, last 12 years.
Misguided. You are misguided by your erstwhile advocate.
And that's why we have taken change in July 2024. Despite service of this application, defendant is unrepresented. We are pleased to pass protective orders. Defendants serve their affidavit in opposition. Then paragraph 24, page 9. The plaintiff reiterates that the omission to lodge the writ of summons was neither deliberate nor attributable to the plaintiff. The plaintiff is unaware of the process of law.
No, Mr. Ghosh, couple of things you have to address. First thing is that even the writ of summons was not served or not taken out in time, but defendant, you please, defendant was aware of the suit.
And copy of the plaint was handed over. Those are my averments on affidavit.
You are coming to institution of the suit for the first time today.
May I indicate the fact?
When did you appear in the suit?
We appeared in the, there was the first interlocutor.
Answer me, when did you appear? 2012. So you are conscious. Don't say no. You are conscious of the suit.
I think we were conscious.
Yes. Now, question is, when the defendant is conscious of the suit, whether this can be dispensed with or relaxed.
Absolutely. Whether your lordship has the discretion or the power.
That
Question
part.
is
That legal part.
That's the legal part. Now,
Second thing, you have an excuse. That you have explained.
tried to explain.
Whatever
subject
that
to
might
your
be, you have tendered an explanation. Whether that can be accepted, whether this provision or this limitation can be extended, and whether this is mandatory or directory.
Absolutely directory. It can be extended
So fine.
provided the honorable judge is satisfied with the.
Shows
It
some
is not
judgment.
a closed chapter. That's all I'm saying. But kindly, my lord, first takes, my lord, the division bench. My learned friend has shown, my lord, two single judge judgments, my lord. First, may I show, my lord, 2014 3 Calcutta Law Journal 437. Division bench judgment decided over by Justice Ashim Kumar Banerjee, my lord. Right, 2014 3 Calcutta Law Journal 437.
Which para you are referring to?
Kindly, my lord, come to, my lord, after discussing the entire, my lord, gamut of, my lord, decisions, my lord.
This is not paragraph.
This is not paragraph. Kindly, my lord, come to, my lord, internal page number 10. Your lordship will find the page number at the top of the page.
Page number 10, yes.
Yes. Kindly see after the bold heading APD number 230 of 2010.
It is true that.
Yes.
No, object of writ of summons.
In the above suit, my lord. The last paragraph, in the above suit.
No, just a minute.
After saying APD number 230 of 2010. In the above suit, the plaint was filed on 28 March 2003.
The point I have placed before you is answered in this part. The object of service of writ of summons. If the defendant is otherwise aware of the institution of the suit.
The writ of summons is to make him aware that the suit has been filed against him. If the defendant is otherwise aware of the institution of the suit by reason of participation in interlocutory proceedings or any parallel proceedings, the gravity of non-service or unduly delayed service of the writ of summons would obviously be mitigated. In some cases, it may happen that due to prolonged talks of settlement between the parties, the plaintiff has refrained from taking steps of service of writ of summons of the defendant. In such cases also, the conduct of the plaintiff would not be so deplorable so as to punish him by dismissing the suit. It is true that the procedure is the handmaid of justice and procedure technicality should not be allowed to defeat substantial justice. However, at the same time, an indolent litigant would not deserve sympathy from the court. One cannot be allowed to take the process of law lightly and burden court records unnecessarily. Just as the provisions of Litigation Act debar a person from approaching a legal forum if he has slept over his right, the plaintiff has also filed a suit as slept over deserves no sympathy from the court. In the light of the above discussion, let us now take up the 4 appeals one by one. In the APD number 230, in the above suit, the plaintiff was filed on 28 March 2003. For 6 years, the plaintiff took no steps in the matter. In February 2009, the plaintiff made an application before the learned master of the court praying for issuance of writ of summons and for leave of the sheriff to accept the same. When ordered at 24 February 2009, the learned master.
The observation is that after 6 years, they came with an application, they came with an explanation which is vague and unacceptable. Still, that was allowed.
Still, that was allowed. Because ultimately, my lord, I have paid 50,000 court fee. I have approached this honorable court. Why should I, for this mere technicality, why should I let my suit, my lord, be dismissed?
Any other judgment?
And my lord, now, my lord, kindly see the special bench judgment where my lord was presided over by Honorable Justice Surendra Singh Nijjar and Justice, it was comprised of Justice Nijjar, Indira Banerjee and Justice Aniruddha Bose. Kindly come back, my lord. This is an unreported judgment. I'll give my learned friend a copy.
Which para you are referring to?
My lord, kindly, my lord, comes to, my lord, page number. There's no page number, my lord. Kindly come to first, second, third page, my lord.
Do one thing.
Fourth page, my lord.
Take it back, make marks.
Your lordship gives me liberty, I will make marks. But this, my lord, clearly holds that the court has discretion.
I am not passing any order today. Let me go through these judgments.
My lord, is it my lord's pleasure that we mark it and give it to your lordship's court officer by the end of today's proceeding? My lord, I should.
I will reply. I'll hear you reply in time. Not now. Heard in part, adjourned to couple of days after. I'm not delaying this matter.
Yes.
Short date. 12 is okay?
Absolutely. You'll be here. The interim order in GA2 be extended.
12 February, interim order is extended till date.
In GA2, madam.
In GA2, interim order passed in GA2 of 24 be extended till date.
Item number 4. Item number 4.
The other side is not present.
Who is the petitioner? None appears for the petitioner, though the caveatrix is present. Adjourned to 6th March.
Item number 6.
Have you got any order? देखिए ये कोথায়?
I'm for the plaintiff.
Yes. GA5 of 24 was disposed of in terms of the order dated 30th August 2024. Therefore, this GA shall not appear in the list any longer and be so treated. Now, what is the status of the suit?
My senior is not here currently.
WS is filed. Department shall furnish a report as to whether writ of summons were served upon the defendant, whether all of them appeared, or whether they have filed any written statement. The report shall appear in the list on 7th March.
Item number 7.
What is GA2?
My lord, GA2, my lord, is my application for rejection of plaint in the alternative for return of plaint.
Why?
Because, my lord, the
commercial matter.
It's a commercial matter. Yes. Matter.
I've heard it in part.
Your lordship has heard it in part. We have submitted a.
When the suit was filed?
Suit was filed in 2019, my lord. Subsequent, my lord, to the Commercial Court Act coming into existence, and subsequent to, my lord.
It's a commercial dispute.
It's a commercial dispute, my lord.
It should be returned, not rejected.
Returned, yes. And thereafter, they'll have to comply with, my lord, Section 12A mediation requirement. And then after they lodge the fresh suit.
So currently, we're concerned with whether to return or to reject.
Yes, yes.
Because rejection cannot be done at this stage. This was given in the order of that was in Patil's automation.
Patil automation. Yes, I've submitted
This
that.
order shall not be effective until 2000 some date in 2022. And rules were framed in 23, I think.
Yes. Yes.
23. So cannot be rejected. It can be returned.
It can be returned.
Lakshmi Palifab.
Yes, it can be returned. Thereafter.
I am led by Mr.
On the last occasion, your lordship had been pleased to direct us to file our written notes. It's not then the
You're
order.
for Union of India.
The railway. No, they are for the union. The railways. They have filed the suit pertaining to carriage of goods by the railways.
Written notes of argument is filed on behalf of the defendant. on behalf of the plaintiff be kept in record.
And the defendant also, my lord.
The written notes of argument filed by the parties be kept in record. When Mr. Lahiri will come?
That hearing is concluded, your lordship can
Come
reserve
Friday
the
then.
judgment.
Friday means? 2 days Tuesday.
You can make some further concluding submissions and then your lordship can pass the judgment. Grateful, man.
Item 8. Item number 8.
My lord, I am appearing on behalf of the defendant petitioner, my lord.
What is GA5?
My lord, this is an application for for amendment of the plaint, my lord. Written statement, my lord.
You're for defendant.
For the defendant.
Is it allowed or hard?
No, my lord.
Affidavit in opposition is filed against GA5 of 24.
My lord, I am praying 3 weeks time to file my reply, my lord.
Let the same be kept in record. An accommodation is sought for by the learned counsel for the defendant for filing affidavit in reply. The same shall be filed on or before the returnable date. Let the matter appear in the list. I have to accommodate also. 24th February.
Grateful.
Item number 9 and 10.
This matter, your lordship passed.
Last order substitution or something like that.
Your lordship passed the order on 12 December.
That is done or not?
Also, my lord, directly for permission to submit the death certificate of Nadir Chand Bari. Nadir Chand Bari died on 27th November 2023. Now, my lord, that is also recorded.
Produced certified copy. It was produced.
Yes, my lord, and your lordship also accepted that. And thereafter, your lordship passed the order on 14 January 2025. Now, my lord, your lordship gave the accommodation to the other side. Now, my lord, your lordship, this is a matter where only the proceeding of
Just a minute. Just a minute.
7 is to be contested by us as the legal heirs of Nitai Chandra Barik and Nadir Chand Barik, because they have died and now we want to contest as by filing our appropriate affidavit, whatever will not, your lordship will kindly consider those.
What is GA7 and GA8?
GA7 is the application of ours for substitution of after the death of Nitai Chandra Barik, who was the caveator in respect of this PLA number 277. Now, so far the
Just a minute. One by one. Please come one by one.
Yes, Willard. And thereafter
GA. This is GA
7. GA7 of 2020.
Substitution.
Substitution of the legal heirs of Nitai Chandra Barik. Nitai Chandra Barik died in 2011. 6th October 2011.
Then the other GA?
Other GA is GA number 8 of 2024, where, my lord, she herself prays that in 277, PLA number 277, the legal heirs of Nitai Chandra Barik and Nadir Chand Barik be substituted. Either ex parte hearing or substitution. My lord, I do not know.
Substitution of legal aid. This GA7 is filed by?
Filed by us. That is the heirs of Nitai Chandra Barik.
Caveator or caveatrix?
Caveator heirs.
Now you are defendants.
I am defendant of PLA number 277. I want to. Because I want to contest that.
In TS 2012. This is now TS 2012. Your defendant number?
Well, I have not yet come forward as defendant because we want to be substituted after the death of 1 of 12. Yes.
1 of
1
12.
of 2012.
Who filed this application then?
That application has been filed by my other side. In 2001, PLA number 277.
This is not filed by the other side. Defendant number Jodunath Barik and
application is filed by us. Yes, Mula. We want to be substituted after the date of
yes. So these are by caveators.
caveators. Caveat.
That's what I'm asking for.
Legal heirs of caveat. And while this application was pending, Milord Nadir Chand Barik, one of the legal heir, has died. And thereafter, your lordship, on your lordship direction, Kolkata Municipal Corporation produced the record, the death certificate, wherein it appears that on 27 November 2023, Nadir Chand Barik also died. So, Milord, our application is along with the supplementary.
An order be passed directing discharge of caveat.
No, my lord. This is not discharge of caveat. This is the application where substitution.
Mr. Chakraborty, let me understand. Don't confuse. This is an application GA 7 of 20. Specific prayer is order be passed directing discharge of caveat.
Well, that particular prayer has been considered also by my lord's previous judges, who said, my lord, this is purely an application for substitution and prayer B will be allowed. Not A, really. That discharge.
No, B cannot be allowed.
The discharge of caveat in the sense because that caveat is no more in existence because of the
death of the person.
So that particular caveat may be discharged because of the only reason that we are now want to be substituted for the purpose of filing our caveat.
So TS cannot be disposed of. There cannot be no existence, only there can be substitution. Who filed this application?
This application has been filed by us.
Then why say no? It's a prayer B, order me passed, necessary directing. There is no existence of further TS. That is prayer B.
Well, we kindly look at prayer C. I'm sorry.
Then wipe the prayer A, prayer B.
Not necessary. As of today, is it not?
Don't say no.
I'm sorry, Milord. It's not necessary today, and I wanted to mean that.
So you want addition of Jodunath Barik?
Yes.
Nadir Chand Barik?
Nadir Chand Barik cannot be added today.
So legal heirs of Nadir Chand Barik can be added.
The supplementary. Okay.
And Shubhadra Kanjilal, so and so, they may be added as a party.
Yes.
As a contest, added as a defendant.
As a defendant.
So very supplementary affidavit.
Supplementary affidavit is there, Milord. Milord is there. Supplementary affidavit is dated, Milord, 1st August 2024. Para 4. Para 4 is important. Of 1st August 2020.
So they are to be added.
They are to be added along with the other heirs of Nitai Chandra Barik.
Right, I got it. Now, so far as this application is concerned, same prayer.
The other application, that is GA number 8 of 2024, filed by her in respect of the same PLA number 277, who says that no, you add all this. Well, we will kindly look at the prayer of GA 8. Well, we will kindly look at paragraph 3 and the prayer.
Same prayer.
Same prayer.
Same names can be added.
Yes, Milord, all the names, because she knew at that time that Nadir Chand Barik also died.
So I'm allowing both the applications.
I believe so. I respectfully submit, Milord.
আপনার যে অ্যাপ্লিকেশন ঘুরিয়ে দিন মাইক্রোফোনটা আপনি যে অ্যাপ্লিকেশনটা করেছেন উনিও একই কথা বলছেন আমি অ্যালাউ করে দিচ্ছি
দেবো
দয়া করে আমাকে একটু হিয়ারিং এর জন্য সময় দিন।
উনি যা চাইছেন আপনিও তো তাই চাইছেন।
না লর্ডশিপ, আমার প্রথমেই আছে এক্সপার্টি হিয়ারিং এর জন্য প্রার্থনা জানিয়েছি, যদি সেটা নট অ্যালাউ হয় তখনই সেটা, কিন্তু কেন এক্সপার্টি হওয়া উচিত হ্যাঁ সেটা আমি লর্ডশিপের কাছে হিয়ারিং করে প্রমাণ করার অনুমতি প্রার্থনা করছি। লর্ডশিপ, প্রথমেই আমি প্রার্থনা জানাচ্ছি দয়া করে লর্ডশিপ যদি 13 মার্চ 2023 আদেশটা একটু দয়া করে দেখেন। 13 মার্চ 2023।
আপনি কোনো লয়ার নেবেন?
না না লর্ডশিপ,
লিগাল এড থেকে লয়ার দেবো?
না না আপনি দয়া করে দেখুন আমি কিভাবে প্রমাণ করছি। দয়া করে আমাকে একটু সুযোগ দিন লর্ডশিপ, সব সত্যি সামনে আসবে। কিভাবে অনারেবল কোর্টের আদেশের অবমাননা করে এই অ্যাপ্লিকেশন ফাইল হয়েছে। অনারেবল কোর্টের আদেশ আছে পার্টি অ্যাড করার, কিন্তু কেভিএট ডিসচার্জের কোনো আদেশই নেই। এছাড়া ওনারা এখন সুদ নাম্বার হচ্ছে TS12012, সেটাকে PLA তে ট্রান্সফার করে এবং সেই PLA তে ওনারা কেভিএট ফাইল করবেন। এটা কি কখনো সম্ভব লর্ডশিপ? আপনি দয়া করে শুধু 13 মার্চ 2023 আদেশটা যদি একটু দয়া করে দেখেন, রেকর্ডে আছে, পাওয়া গেছে।
Possibly she wants to show 13th March 2024.
No, 23, not 4. আমি অনারেবল কোর্টের আদেশ দেখিয়ে লর্ডশিপের কাছে প্রমাণ করব যে কিভাবে অবমাননা করে এই অ্যাপ্লিকেশনটা ফাইল করেছেন।
আপনার কাছে একটা কপি হবে, দেবেন?
ওই তো
অর্ডারের কপি দেবেন?
না সেরকম কিছু তো বলা নেই।
লর্ডশিপ, ওটা কি 23rd মার্চ, না 13 মার্চ 2000?
13 মার্চে সেরকম কিছু বলা নেই।
হ্যাঁ দয়া করে সেকেন্ড পেজ।
সেকেন্ড পেজে কোথাও বলা নেই সেরকম কিছু আপনি যেটা বলছেন।
না ওটা আমি আমি অর্ডার থেকে প্রমাণ করব। সেকেন্ড পেজে আছে নদের চাঁদ বাড়ি বসবাস করে 2/1A রাজা রাজকিষণ স্ট্রিট। দয়া করে
হতে পারে 2/1 এতে আছে, বলা যেতে পারে, কিন্তু আমি কমিশন, আমার কাছে যে রিপোর্টটা এসছে,
হ্যাঁ বলুন, দয়া করে আদেশ করুন।
কমিশনার থেকে,
হ্যাঁ
কলকাতা মিউনিসিপাল কর্পোরেশন থেকে, সেখানে যেটা প্লেস অফ ডেথ আছে আমি সেটাই নোট করব। আপনি সুটে প্রমাণ করে দিন যদি সাক্ষী হয় যে ওখানে মারা গেছেন, ওটা খুব বড় জিনিস নয়। উইলের ব্যাপারে সেটা খুব বড় কিছু ব্যাপার নয়।
ঠিক আছে লর্ডশিপ, যেটা বলবেন। এবার
আর যেটা অ্যাপ্লিকেশন করেছেন নাম্বারটা TSC থাকবে, এক্সপার্টি হবে না। আর আপনারা যারা সাবস্টিটিউট হতে চাইছেন তাদের সাবস্টিটিউট করে দিচ্ছি আমি।
লর্ডশিপ, তার আগে আমি একটু প্রার্থনা, দুটো একটু প্রার্থনা জানাচ্ছি লর্ডশিপ। লর্ডশিপ, এই ব্যাপারটা আমি একটু জানাচ্ছি যে এই উইল কেন, হ্যাঁ
সেটা এখন শোনার প্রশ্ন আসছে না।
আচ্ছা
উইলে যখন উইল ব্যাপার সাক্ষী হয়ে গেলে,
হ্যাঁ
যখন আর্গুমেন্ট শুনবো তখন সেই জিনিসগুলো শুনবো।
হ্যাঁ
এই মুহূর্তে সাবস্টিটিউশন ব্যাপারটা হচ্ছে ইস্যুতে।
হ্যাঁ
আপনারা এবং আপনারা দুজনই একই সাবস্টিটিউশন চাইছেন, আমি সেটা অ্যালাউ করে দিচ্ছি।
না না লর্ডশিপ, আমার সাবস্টিটিউশনের মানে আগের পেয়ারটা হচ্ছে এক্স পার্টি আমি প্রার্থনা করেছি, কিন্তু কেন করেছি দয়া করে লর্ডশিপ, 10 ডিসেম্বর, হ্যাঁ
এক্স পার্টি হলে আপনার সাবস্টিটিউশন হবে না, আপনি ডিফেন্ডেন্ট।
হ্যাঁ আমার শুটেতে।
সুটটা কি আপনি করেছেন?
হ্যাঁ TS12012 আমি করেছি। আমি বেনিফিশিয়ারি হয়ে
TS1 এ পার্টি অ্যাড করছি, এক্স পার্টি হবে না। যখন পার্টি এসছে ওটাকে এক্স পার্টি করা যাবে না। এটা কে মামলা ফাইল করেছে? TS1 আপনি করেছেন।
লর্ডশিপ আমি করেছি।
It was PLA number 277 of 2000.
সাবসিকুয়েন্টলি এটা TS নাম্বার হলো যখন কন্টেস্টেড হলো, তাতে একজন ডিফেন্ডেন্ট মারা গেছে,
হ্যাঁ
ওয়ান মারা গেছে,
হ্যাঁ
তার সাবস্টিটিউশন হবে।
হ্যাঁ
আপনিও তাই চেয়েছেন TS1 এ।
হ্যাঁ লর্ডশিপ, দয়া করে একটা অর্ডার 10 ডিসেম্বর 2014, 10 ডিসেম্বর 2014, পেজ 3, লাস্ট প্যারাগ্রাফ। TS 12012 তে।
আগে কি অর্ডার হয়েছিল সেই সময়ের ব্যাপারটা আলাদা, এখন
না 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 রসিদ রিলেটেড,
আপনি
ভীষণভাবে
পরে
রিলেটেড।
পড়ে আসুন, তারপরে শুনবো।
আচ্ছা রসিদ দয়া করে আমাকে একটা তারিখ নয় দিন, দয়া করে আমি
আপনি
এবার
যে
আদেশ করবো।
জিনিসটা চাইছেন সাবস্টিটিউশন করতে,
হ্যাঁ
আপনি ফাইল করেছেন তো?
হ্যাঁ TS 12012 আমি ফাইল করেছি।
আপনি এই অ্যাপ্লিকেশনটা আপনি ফাইল করেছেন GA8?
হ্যাঁ GA8
আপনি কি চেয়েছেন GA8 এ?
GA8 এ আমি লর্ডশিপ আমি আজকে তো GA720টা পড়ে এসেছি, যদি GA7টা দয়া করে আদেশ করেন।
আপনি GA8টা পড়ে আসুন,
ঠিক আছে
একই প্রেয়ার দুটোতে।
দাদা আমি
My lord takes
আমার
them the time.
আমার
I will be only besieging your lordship. Besieging. Well, we'll
Lordship,
look at that division bench judgment of the
Come on the next date. Show on the next date. One is enough for me.
লর্ডশিপ
Heard in part adjourned to 11 February. আপনি দুটো অ্যাপ্লিকেশন পড়বেন,
হ্যাঁ লর্ডশিপ
দুটোই একসঙ্গে নেব, দুটোই সাবস্টিটিউশন,
হ্যাঁ
দুটোতে একই প্রেয়ার আছে।
হ্যাঁ আর লর্ডশিপের কাছে আমার প্রার্থনা 10 ডিসেম্বর 2014
নিয়ে আসবেন পরের দিন,
হ্যাঁ, আর 24 আগস্ট
নিয়ে আসবেন অর্ডার গুলো।
আমি চেষ্টা করব, যদি না হয়
এখানে নেই, 14 এর অর্ডার এখানে
লার্নের রেজিস্ট্রারকে যদি দয়া করে আদেশ করেন
এই নাম্বারগুলো নিয়ে
নেক্সট তারিখে যেন নিয়ে আসেন, পাঠিয়ে দেন উনি।
date গুলো কি?
হ্যাঁ হ্যাঁ ডেট হচ্ছে
লিখে দিন
10 ডিসেম্বর 2014 আর 24 আগস্ট 2022। এই দুটো আদেশের অবমাননা করে ওনারা এই অ্যাপ্লিকেশন ফাইল করেছেন, আমি সেদিন প্রমাণ করে দেবো।
প্রমাণ করার দরকার নেই, কন্টেম্পট অফ কোর্টের পিটিশনের হিয়ারিং হচ্ছে না, মামলাটা নিয়ে এগোন, শুধু শুধু দেরি না করে।
লর্ডশিপ
is fixing 11th
12 February.
12th February.
No, not 12 February. 11 February.
Item number 11.
একটা মামলাই না।
Item number 11.
I am the administrator pending till it. I filed the GF4, my lord.
My
Yes.
learned friend has been appointed as an administrator, my lord. My learned friend was appointed as an administrator, my lord, pursuant to a order passed in my application, my lord. My lord, the grounds taken by us was that the executor was not performing as per the terms of the will, my lord. And there are other issues.
What are your prayers?
My lord,
Prayers,
here,
yes.
my lord.
My lord,
Inventory, my lord. My lord, she went to take inventory of few lockers, my lord. Those lockers.
Order may be passed directing
Order must-
concerned branch manager. Which branch?
my lord, sir, page number
Your-
78, my lord. Annexer F, page number 78. 78, my lord. Indian Bank, Gorihat branch and Bank of Baroda, Lake Market branch. Yeah. Annexer F, page number 78. Which is mentioned page number 8.
Who is your other side?
My lord, there is, it is.
PLA,
non-
this is PLA.
PLA,
Yes.
I am appealing for one of the beneficiaries, my lord.
Who is the executor?
My lord, the executor was Kamala Pushpanathan, my lord. She was not performing well, my lord. She has suppressed few facts, my lord. We brought into records, my lord.
PA4 of 24 is filed by the administrator pendant like praying for passing necessary directions to the branch managers of Indian Bank,
At present,
Gorihat branch, as well as Bank of Baroda, Lake Market branch, to allow the administrator pendant light to take inventory of articles lying therein, lying in the bank lockers. Bank and locker details are in page 78, annexure F of the application. Heard the learned counsel for the beneficiary. Prayer A of the application is allowed. Directions are hereby given to the branch manager of the two branches as above mentioned to allow the administrator pendant light to open the bank lockers and prepare inventory on inspection. Copy of this order along with copy of annexure F page 78 shall be served by the manager of the concerned branch for their information and doing the needful. Full stop. Once the inventory is prepared, the same shall be filed by the administrator pendant light in the form of an affidavit, in form of a report in this court. Fix 27 February for further order.
My lord, it may take few more time, my lord, because the bank is holding 1K.
13th March. 13th March for further order.
Much obliged, my lord.
With my
No, no, GA থাকবে for further order.
Item number 12.
My application, this is an interim application, in probate application, in which your lordship directed, permitted me to use the supplementary affidavit. In the main application, interim application, I have paid for various interim release, but I have to cross the first hurdle. First hurdle is, it has already, this court has directed the probate application to be converted into application for letters of administration because the executor has renounced executorship. That has been allowed by Justice Krishna Rao. Now, while carrying out the amendment, the department pointed out that in the body of the first page, in the body, the name of Secretary of Ramakrishna Mission should be, we had only written Ramakrishna Mission, the name of the secretary had to be inserted. Now, so the entire amendment, because of that, the amendment has not been able to carry it out. Then we mentioned the
What is supplementary one?
supplementary affidavit I filed.
Your lordship, I will take the objection.
Just kindly give me a minute. Now, I mentioned the matter before Justice Apurva Sinara, then what? My Justice Sinara allowed that prayer, but my lord directed the cause title should be amended. But actually, it's not the cause title. Just below the cause title, application. This is the application of Secretary Ramakrishna Mission. That your lordship has allowed by your lordship's order.
Proposed amendment is to be allowed.
Yes, proposed. That is just, your lordship kindly come to the supplementary affidavit. Just in the first page, the rest of the amendment has been allowed by Justice Krishna for conversion. That order is here. Only the first page.
Order of conversion is here.
Yes.
Where is that?
Your lordship, may I just point
I
out?
will hear you. I will hear you.
Without going into so many things, I'll tell you from the cause title which they have amended. The direction which was given by the department and your lordships also was that the Secretary of Ramakrishna Mission has to sign. And that's what has to be written. Because Secretary of Ramakrishna Mission is an organization which is registered entity and legal entity which can empower its secretary to sign. Who has signed here? He is not the secretary. He doesn't say that he's the secretary of Ramakrishna Mission. He is a secretary of one of the entities within Ramakrishna Mission.
He is the
No, that is not known. That is not known, sir. Your lordship will have a look. It says Secretary of Ramakrishna Mission, Golpark Institute of Culture. Golpark Institute of Culture is not Ramakrishna Mission. Ramakrishna Mission, that's an institute within Ramakrishna Mission. There we may have a secretary. This person is secretary of that. But that is what he says. In his affidavit also he says that.
Any authorized person on behalf of Ramakrishna Mission can be signed.
So how we know that authorization?
That is not known.
Taking out this false.
Let me do one thing. In order to avoid controversy, any authorized person, let the Ramakrishna Mission is a legal person.
This gentleman is authorized.
Your lordship,
do not know. Then authorization later is to be produced. That's the complication.
Yes.
No,
No, your lordship, it is
any person authorized.
You are very well, your lordship.
But that order is to be passed.
Your lordship, the general secretary, being advised here with my learned friend, the General Secretary is the person who is empowered to sign on behalf of the Ramakrishna Mission and not some secretary of somebody.
That court cannot say who will be authorized.
Right. So the Ramakrishna Mission has to come and say, Your Lordship, the Ramakrishna.
But let me one by one. Where is the earlier order?
Earlier order of Justice Krishna Rao, there are two orders. This is the order of Justice Krishna Rao.
Your Lordship, page 45 of the application.
Applicant Shami Suparnananda, Secretary, Ramakrishna Mission. He made this application. That's why this application.
Your Lordship, Ramakrishna Mission. Thereafter, it says Ramakrishna Mission, Institute of Culture, Gold Park. There is a difference between them.
That is, the application was filed. That was noted in the order.
Yes.
That's
Your,
why his name-
but Your Lordship,
Department said his
because
name should be there. That's why.
but Your Lordship, what is happening is that's what I've said. What is happening is he is not the secretary of Ramakrishna Mission. He is only the secretary.
I got your point. Where is the application? Which you want to amend? Where is that
Your Lordship
application?
will see the affidavit which they have some supplementary affidavit which they have filed. In that also he says that I am the secretary of this institute.
Mr. Sinha, let me understand the things.
Yes.
Where is the cost title?
Your Lordship, that's page 3 of the supplementary affidavit.
The application, the department said the secretary name should be there. That already that was already.
That was originally Ramendra Lal Odi.
Yes, he renounced.
He was, Your Lordship, the solicitor. There
He renounced. That's why it was converted into application for letter of administration. And here,
So I think better the authorized signatory of Ramakrishna Mission, the authorized person. Ramakrishna Mission is a legal entity.
took out that application. I'll produce a letter of authority in his favor. He is the secretary. I'll produce a letter of authority. No problem. I'll produce. I'll produce a letter of authority.
Ramakrishna Mission is a legal entity or not?
He is the secretary. Yes.
Question, I'm not interested. Who is secretary, who is not? Question is whether Ramakrishna Mission is a legal entity or not.
Yes, legal entity. Yes.
Legal entity. So any authorized person will sign that. Shami Suparnananda was the authorized person. That's why he moved. No authorized person should be named in the cost title. It should be in the name of Ramakrishna Mission.
Yes.
If the department says it should be name of specific person, department is wrong.
But that's why all these problems are. Otherwise amendment would have been carried out.
No, Your Lordship, the problem is they are still amending with Ramakrishna Mission, Gold Park Institute of Culture. That is what they are writing.
What is in the will?
The will also says this Ramakrishna Mission, Gold Park Institute of Culture.
That will be that.
But so Your Lordship, no, because I can give it to a particular department or somebody of a legal entity. But when somebody files it in court, it is the legal entity has to file. Institute of Culture is not a legal entity. Institute of Culture is within of the folds of Ramakrishna Mission, which is the legal entity. So I may give money to.
How can I know this?
Your Lordship, then they have.
How can I know this?
Your Lordship, then they have to produce. Your Lordship, then they will have.
Is your contention?
Yes. So
have you filed anything in writing?
I have not got an opportunity. Gives me an opportunity. I will find an opposition to this regard.
Why are you opposing to all these things?
Because Your Lordship,
because he's got another will.
Your Lordship, come next. This is not the way of hearing. Come on the next date.
Kindly, this technical amendment, I'll produce a letter of authority. Kindly, so I can proceed with the rest of the application. Let him file.
Problem is that you are more interested to speak out, less interested so that I can understand. So come on the next date.
I'm not.
Come on the next date. File everything in writing, and I will understand. Let me pass order. I will go to my chamber and I will think. Whatever order may be passed, I will pass.
No, this is a technical technical thing, my lord, because the department is insisting. Justice Sinara said you insert the
next matter.
Your Lordship also died.
Adjourn to 6th March.
Only the estate is still with you.
Item number 13.
Mr. Sinha, either you shut up your mouth or come with a proper application.
Your Lordship, it's not my application. What can I do? I can only indicate what they are doing. Which is
application there?
Not my application. It is their application.
I'm not pressing the release because this initial hurdle has to be crossed.
Your Lordship, they have filed same applications multiple times, and there are various orders where they have then not pressed it.
That is the issue. That's why what I'm saying. All of you are interested to submit your own things without allowing me to understand the things. All right, go on. One after day I will fix for hearing without passing order. Adjourn to 6 months.
My client is suffering.
Next matter.
Item 13.
If you want to get order, let me understand the thing. If you are not patient enough, if you are more interested to make submissions, go ahead.
I'm patient, man. I'm
Next matter.
Item number 13.
13, my lord, is my application for condonation of delay and restoration of
ডিপার্টমেন্ট
a
থেকে ডাকো তো, কে বলেছে ওখান থেকে? ডিপার্টমেন্টকে ডাকো। আমার চেম্বারে আসতে বলবে আর ফাইলটা পাঠাবে।
My lord, item 13 is my application, my lord, for condonation of delay and restoration of a PLA, my lord. No caveat has been filed in the PLA, my lord, on 7 January 2025. Pursuant to a direction, my lord, had passed a direction for the registrar to file a report. From that report, for the first time, my lord, my advocate and record came to learn, my lord, that the PLA itself had been dismissed for default long time back. It was apparently appearing in the list, my lord, of my lord Justice Krishna Rao in 2023.
When it was dismissed for default.
My lord, dismissal order, my lord, will find from page 26 and 27 of GA1. My lord has GA1. That's 30th November 2023. 30th November 2023. But my lord, this was not known to my advocate. My lord will kindly consider my lord's order of 12 December 2024 at page 24. It was ready for hearing. The department has certified it to be ready for hearing. I had paid court fees on 19 September 2024, my lord, of 50,000. I've deposited with the registrar of this honorable court, my lord. That also I've disclosed. All
What is the
apparently,
explanation?
my lord will kindly come to page 6. Firstly, my lord, there have been 2 changes in advocate on record of the PLA. The entire
GA1 of 25 is filed by the petitioner. I take to chalao to. Praying for setting aside the order dated
30th November 2023.
30th November 2023, whereby the instant application was dismissed for default. Full stop. Next matter. The petitioner has explained why the matter was dismissed for. Would you dictate? Why the matter was dismissed for default? There is proper explanation of delay in filing the instant application. Let the application GA1 of 25 be allowed. The instant PLA application be restored to the original file. Fix 6 February for further order.
Obliged. Deep refer.
Item 14. Lord, this was for grant of probate, Lord. We had initially
So many applications are
Yes,
pending.
Lord.
We've settled the entire matter. The
Everything
probate has been settled, and they have agreed, my lord, to for your lordship to grant the probate in terms, my lord, of a settlement which the parties have entered into. And
No,
lord,
we are concerned only with one thing, whether will was properly executed or not, all these things.
correct.
So if you agree to that,
Correct.
withdraw
Yes.
your caveat.
Correct. No, his
By caveat it was there. It was marked as a contentious cause. It is at this stage, my lord, with the party.
Evidence is over.
Yes, my lord, you are in the evidence stage.
we are at the evidence stage.
Issues are framed also.
Issues framed, evidence stage, parties. Well, it's a brother and sister.
Brother and
mothers-
No issue, you did not cross-examine.
Correct.
That's all.
My lord, we have entered into terms of settlement, maybe taken up.
Terms of settlement cannot be looked into in that way. Do not oppose it. Let it go.
Yes, yes.
Yes, lordship will record that they are.
So
giving
issues are there.
Yes, my lord, issues have been.
So I'm fixing for witness action.
No, my lord, we have settled.
There's
Parties have settled the matter.
now it will
the
proceed as a non-contentious.
lordship will just grant the probate in view of the
You
settlement.
produce the will is to be marked first.
Has been done.
That is done.
Yes.
Where is
has
that?
been done.
Without a witness action, it is done.
Witness action has started, my lord, on commission. My lord, the plaintiff.
That's what I'm asking
yes,
for.
That has been done. But
Will is marked.
Yes,
Death certificate.
all marked. Will, death certificate, all those have been marked. The codicil also, I think, my lord, all have been marked. They are on record.
Was
as
there any cross-examination?
Yes,
Report টা কোথায়?
So they have not cross-examined.
Attesting witness?
Yes. No, my lord, yes, the attesting witness, they have not cross-examined. So
Examined.
yes, chief has done. All the exhibits done. Cross-examination.
Executor, attesting witness, both are done.
My lord, attesting witness is done, not the executor.
So I'm fixing it for argument.
There's nothing to argue because parties have settled.
Court may have a clarification.
That if the will is marked and the testing witness has deposed, and my lord, the parties, my lord, the only opposing.
Mr. Mitri, you know, probate court is not a mechanical court; it's a
But,
court of conscience.
My lord, I would like to, my lord, draw your attention to, my lord, Carapiat's case, which is very clear. Carapiat says.
Carapian's case, not maybe that's true, but so far as probate is concerned, mere non-cross examination does not prove the will.
No. Now they have filed. My lord, they have filed an affidavit saying that I have no objection. I'm withdrawing my caveat. So, my lord, that hurdle which your lordship is thinking, my lord, perhaps goes.
But in that case, if something comes to us, appears odd to me, I will pass order without hearing you because you are not asking for any argument. If you think everything is right,
yes,
don't argue. I will pass order according to my conscience.
Why? My lord,
But don't dictate me to pass the grant the probate. That I won't do.
Lordship thinks I'm dictating you.
Either two options.
I don't dictate, my lord. I can't dictate the court. Least of all, your lordship.
That case, fixing for argument, you say I may go, let me go through the record. I may put some questions, may not put some questions, then I will pass judgment. Or if you think it should be passed, need not be their argument, you say that. I'll just fix it for judgment. But if something comes out to my mind,
May I suggest this? Lord, lordship keeps it on another date. If lordship has any queries, lordship can put.
That is in the form of argument.
Lordship can put the queries to us. We'll try.
That is in the form of argument.
We'll assist your lordship, my lord, to that extent.
देखिए उल्टे देखिए एक तो. But don't say the court should pass probate.
No.
Some says.
No. That's not what I said, my lord.
এটা কি দিচ্ছ? আমি এটা দেখে অর্ডার দেবো না সাক্ষী দেখে দেবো না উইলটা দেখে দেবো? ফাজলামো করছো?
উইলটা পিএল এর মধ্যেই আছে তো? তাছাড়া তো উপায় নেই। তাছাড়া
কোথায় উইল? Where is will? Can you ask me to pass order?
হবে না। Register rules say.
No.
It is in custody and he used
It's
to
in
get
the
it
custody.
every day.
It's in the custody of the registrar.
Let me have it. Evidence-টা কোথায়?
5th February
No, the
20.
order. Right.
So this is the order, well, what should kindly have a look at it.
I'll not look into it. What is in record?
Witness, my lord.
Evidence-টা কোথায়?
Lord, I'll tell you, lordship. Kindly give me one moment.
Commission এ হয়েছে?
Yes.
Where is the report of the commission? Please fix 6th February for argument. Will is to be produced before this court by the department.
Kindly direct the registrar because he's in custody of the will.
Yes, that is the direction is given. Now, Mr. Mitra, what would I have to do when we'll sit with all these documents without filing a will? Then also we have to pass order granting probate without looking into will.
But,
that is the proposition. Without looking into will, I will pass order.
I didn't say that.
The probate may be passed. That's why I want to look into the documents.
No, I am not.
And I found the will is missing. Don't say this. It can be passed. Court may have to look lot of things.
I am only saying. I'm sorry, my lord, if I have offended your lordship, my lord, because I don't say these things with your lordship.
Fixed argument. I may need some clarifications. Let the will come. Let it be proved. Already it is proved possible.
It has been proved.
That's all.
It has been proved.
That's all. And if I need some clarification, I will ask you this much. Because sometimes I'm asked to pass the grant of probate only on common form. That I won't do.
I haven't said that.
I'm not speaking of you. I'm not speaking of you.
Because, my lord, because of the settlement, my lord, there's a view, my lord.
I understand there is no opposition in grant of probate.
Correct.
That doesn't mean, because probate court is a court of conscience. Lot of things happen.
Correct, correct.
Lot of things happen.
Correct, your lordship is right.
In one case, I refused probate. Why? Two loose papers, rather not loose papers, two blank papers were attached to the will. It was signed. So what does it mean? So let me come on the next day.
I am not.
Come on 6th February.
Communication. Item number 15.
My application. This is my application for grant of probate. Not sure what had happened was, in the affidavit of assets, the locker was disclosed and no value was given against it in the affidavit of assets. So the court had appointed a special officer. The special officer has made an inventory of the locker and found that there was nothing in the locker. Lordship, a copy of the report has been handed over to me, but I'm not aware whether the original has been filed in court or not.
Who filed this report?
Lordship, Mr. R.N. Bondapadhyay, who was appointed by this court as the special officer.
Where is he?
Lordship, I spoke to him. He's perhaps not come to court today.
Come on the next date. Seal khulbe na. Come on the next date. 6th February.
Item 16.
What is my application?
Hmm.
It's an application to record the death of one of the legal heirs with yesterday man. Well, there is a just indicate one thing. There's a certain miscommunication. Well, what's happened? Will kindly see the lost order. Worked in this matter on 19 December, page number 7. Already the order of citation has passed. But subsequently, there's a miscommunication is there. One of the legal heirs is expired.
Who expired?
And it's the wife of the testator, Indira Banerjee. The testator wants
Substitution?
No, all the legals are there. The son is the executor.
Son is the executor.
Yes, the daughter is already there, and the citation has been ordered directly against her.
Legal heirs?
Only two.
Legal heirs only two. Son and daughter.
Son and daughter.
GA 2 of 25 is filed for bringing on record death of one of the beneficiaries.
All the beneficiaries there. The son is the executor and the beneficiary.
And this wife?
The citation is nothing given to the daughter.
Is a beneficiary or not?
No.
Recording death of the beneficiary. No. Recording the death of the wife of the testator. Full stop. According to the application, who is Ashalata Mukherjee?
Daughter.
Daughter of Indira Banerjee.
Yes. Daughter of Indira Banerjee. Daughter of the testator.
Of the testator.
Yes.
Citation was not issued.
No, that's the order of citation already passed. That is in page 7. But there's a little miscommunication between the Aswal advocate and the present advocate.
Let it be recorded. You will them. The deceased left behind her the present petitioner and one daughter, Ashalata Mukherjee. Full stop. Let the same be in record. Full stop. Citation, special as well as general, be issued to Ashalata Mukherjee.
I'm grateful, man.
By the let the matter appear in the, let the application appear in the list on 12th March for further order.
Okay, cool.
GA
GA2, my lord.
What amendment would you like to make?
Amendment, my lord, in the prayer, because in the prayer A and B says Acha Lata and Inzabaji, and in the pleading.
Accordingly, prayer A to C of the application of GA2 of 25 is allowed. And GA2 of 25 stands disposed of.
Great.
Item 17.
Lordship, in this matter, I beg to appear on behalf of the plaintiff. Time and again, your Lordship have been very kind to extend the time of action work, but it couldn't be commenced, your Lordship. Today, my humble prayer would be to your Lordship to extend it peremptorily, or I have instructions to take out an appropriate application. Because the advocate who was carrying on the commission is unwell and not coming to court. This has been extended for several times. I should be very candid before your Lordship. It couldn't be commenced.
When he was appointed?
He was appointed way in 2019. Thereafter, COVID came in. Then thereafter, the conducting advocate who was there, he died out of
Was
cancer.
appointed.
Mr. Sinha, your Lordship. Mr. Prithviraj Sinha.
Order dated 20th September 22.
Yes, no, these were the extensions, but he was appointed in 2018, 2019. Thereafter, the commission work was commenced. And the
Learned counsel for the plaintiff submitted that the learned commissioner is not able to finish examination of witnesses. Full stop. Next para. The learned commissioner was appointed in terms of order dated 18 November 2019. Full stop. Mr. Prithviraj Sinha, the learned commissioner, is not present today. The matter will appear in the list on 13 February. Mr. Sinha shall be present personally on that date and shall explain why he shall not be removed from the and some substitution should not be made. Any payment was made to him?
yes, daily payments were there. We used to make daily payments.
Mr. Sinha shall also explain how much amount he has received as yet, full stop, in the form of affidavit.
Gratefully, Your Lordship.
For framing of issues, item number 18.
It's a ex-party suit. Right to file written statement has been forfeited. There cannot be any issue. The order is unchallenged.
What is 1, 2?
Kindly takes there's an order of 9th of January.
What is GA 1 and 2?
Sir, 1 is for judgment upon admission. There's an admission that GA 2. 1 here.
That was allowed.
Has already disposed of.
Which one?
1 has already GA.
What is 1?
1 was for Lordship has already passed an order on 8th of April 2024. Disposing of GA number 1. May I hand up the copy of yours? Thereafter, Lordship passed an order. No written statement is filed, I have given the report of the.
When GA 1 was disposed of?
It was disposed of on 8th of April 2024. 8th of April 2024.
অর্ডারটা কোথায়?
May I hand up? Then on order of 9th of January 2025, Lordship called for a report.
GA 1 was disposed of.
Yes.
In terms of order dated 8th April 2024. was deemed to be disposed of in terms of the order dated 8/4/24. Still, it is in the list. They said GA1 of 2011 shall not appear in the list. Copy of this order may be sent to the learned registrar IT as well as registrar original site for doing the needful.
Millard, so far as GA number 2 is
Full stop.
concerned, in
Next para.
chapter
GA number 2 is for
chapter 13A. Millard, in the chapter 13A, Millard, there is a report of Millard, the Millard registrar, Millard, learned register. He has said, Millard, no written statement has been filed. Millard, so chapter 13 was filed. If it is filed, chapter 13 wouldn't have been maintainable. By an order of 9th of January 2025, this court, to be on the safer side, Millard, Lordship is absolutely correct, Millard, called for a report in relation to date of appearance and non-filing of written statement to be on the safer side. That's 9th of January 2020. Your Lordship takes the report of the registrar that's annexed, Millard. Lordship will see, Millard, they have not filed written statement.
where is the report? I am not aware of the report.
Part of the GA, Millard. It's there. And Millard, department has sent,
24. আমার 9th যে এটা there is no report in terms of order dated 9 January 2025.
There is already a report in my GA, Millard. It's already. Despite
Mr. Ghosh, I have asked the department to furnish me a report.
Yes.
Should I forego this?
If they do not, then Lordship goes by my report. Yes, Millard. If your Lordship is absolutely.
GA2 কেটে দাও.
Page 73.
তারপরে next para, a report was called for from the registrar original site in terms of order dated 9 January 2025.
Correct.
The report is yet to be submitted. A copy of this order along with the order of 9 January 2025 be resent to the learned registrar original site for doing the needful.
Kindly, Millard, with that, Millard, if your Lordship, Millard, so pleases, kindly page 73 of my application. He has given a report. Lordship also indicates in the order. He will say, Millard, I have given a report. Page 73 of the
Let the matter appear in the list for submission of report on 11th February.
Millard, there is a Millard. Lordship will kindly, Millard, record this. Otherwise, Millard, it will create again, Millard, this.
10th February.
If it commences to Lordship, page 73, Millard.
Maybe. Let this report come. When I call for a report, that is to be submitted.
Millard, in this regard,
Irrespective of the fact whether you have furnished a copy of earlier report or not.
but in this matter, I appear for the defendant number 1A and 1B.
Give us sleep.
Who are the
Give us sleep.
I have given,
But that's
but
all.
only one prayer I am making, my lord. Instead of 10th, can it be on 9th or 11th?
9th is Sunday.
11th,
No, 11th is for testamentary matters. It can be 12th.
because on 10th, I will not be personally.
12th.
It's Millard, Lordship, then Lordship decides the modality, chapter 13A, or my witness will
Let this come. Even if your chapter 13A application is thrown away, Mr. Ghosh, then also you will have no problem.
I have no problem because it's in the ex parte board. There's an order forfeiting the written statement.
That's all.
There is no challenge.
But is it a
10 years have gone.
commercial dispute?
What is the order forfeiting the right to file written statement?
Is it a commercial dispute?
This is not a commercial dispute, my lord.
So if there's an order, if he has applied for extension of time to written statement, if there's an order saying that no, it's not sufficiently explained, then Millard, if the order is not challenged,
Order is there.
Yes, order is there. I'm
Let the report come. Why won't they file this report? When I ask the department to file a report, why won't they do that?
They will definitely. বলে report to be তুলে নাও যতবার তুলে
Item 19.
I appear in this 19 and 20.
That in both these matters, my lord, your lordship will recall, my lord, commissioner was appointed to record the evidence of the plaintiff's witness by through virtual mode. The plaintiff is 80 odd years old, my lord, he is wheelchair bound and he is resident in UK. my lord, today's fixed for framing of issues. My lord, we are carrying suggested issues with us. My lord, two other things.
My lord, I am appearing on behalf of the defendant number 2, my lord. I am praying for adjournment as my client has affirmed an application for amendment of written statement.
That can take its own course. There is no difficulty with it.
No, the evidence will be affected.
Yes.
Perhaps. My lord, of that apart, my lord, the commissioner has conducted a meeting. In course of the meeting, my lord, one issue, my lord, was pointed out by the commissioner because, my lord, this was a suit which was proceeding ex parte, CS 76, which is item number 19. It was proceeding ex parte. Up to 93 questions were put in chief. So, my lord, the commissioner's request, my lord, was for a clarification from the court.
I can understand. I can follow you.
My lord, what is
Suit is yet, issues are yet to be framed.
Yes, my lord, initially.
And evidence has begun to be taken.
Initially, defendant was not appearing. It was proceeding ex parte. We examined the witness in chief. My lord, he came to Calcutta. He was in the box. Up to question 93 was asked. Several documents were exhibited. At that stage, they came up with an application for leave to enter appearance, file written statement. Heavy costs were imposed, but leave was given. Then they have filed. Now it is a contested suit. Now, my lord, the issue, my lord, that the commissioner, my lord, is faced with is whether, my lord, the recording of evidence will happen from question 94 onwards.
Let the issues be framed first.
Very well. I leave it.
Because before framing of the issues, further examination of witness cannot be done.
Very well.
You can start therefrom adopting that. You have
Yes,
to adopt that evidence.
Of course, no doubt.
Adopt that evidence, I can proceed further.
And, my lord,
And so far as for the time being, he is praying for amendment of written statement. Let the leave be given. After written statement, amendment of written statement, issues will be framed.
let them serve the application. My lord.
Yes, serve the
Look at
application.
the nature and character that they propose to amend.
Yes.
Is it filed or not? Let it come in the list.
Just affirm yesterday, my lord.
Not this week.
Deeply obliged.
21.
In 19 and 20, my lord, the same order can be passed. I don't know.
Only not this week.
In 20, whether there is a proposed amendment or not.
Come together.
19.
19, 20. Not this week.
19 only.
20 the question.
20 no, আমার কোনো কোনো instruction.
20 my lord, defendants are the same.
They have brought this.
Come on the next day.
Yes. Deeply.
21.
Deeply.
My lord, this is my application.
এত কম মামলা রাখো কেন? কপাতার মামলা আরো রাখবে।
Lordship, I appear for the plaintiff in this
আর
matter.
আজকে এই প্রত্যেকটা অর্ডার আপলোড হলে তোমরা সবাই বাড়ি যাবে। তার আগে কিন্তু কেউ বাড়ি যাবে না। আমি কিন্তু শোকজ করব।
My lord, I
আমি
appear,
জুডিশিয়াল অর্ডার করে করব কিন্তু বিপদে পড়ে যাবে।
my lord, I appear for the plaintiff in this matter. Your lordship will recall on the last occasion, my learned friend appeared and prayed for further time when prior to that, the time were given peremptorily for completion of the orders of discovery and inspection. They have failed not to take any steps. Now, my lord, the ground made out by them on the last two occasions was that the defendant is very sick. My lord, the fact is that the plaintiff and the defendant reside at the same premises, same floor. And my lord, she is absolutely hale and hearted, just deliberately not avoiding to comply with the court's order. So today, your lordship had fixed it for framing of issues. I have come ready with my suggested issues.
Repeated adjournments were given to the defendant for discoveries, inspection, and disclosure of documents. From time to time, no step was taken by the defendant for this. Order in this regard was passed on 3rd July 2024, 3rd September 2024, 19 September 2024, 13 December 2024, 22nd January 2025. Today also, an accommodation is sought for. Defendant shall explain why defense shall not be struck out on or before the returnable date. Let the suit appear in the list on 5th February. I'm giving an
For arguments, item number 22.
Which one?
The argument.
This one? Tibirwala? Yes. Where is your other side? Mr. Doctor?
For the number 2, Lordship, and because of it on his plate.
All right. One of the point was limitation.
I shall come to that, my lord. I shall come to that. Before that, my lord, may I? Limitation, of course, is a question of law, but before that, my lord, may I show your lordship, my lord, the plain and written statement, my lord, the pleadings on the basis of which the parties went to trial. Because many submissions I find, my lord, from the notes, many submissions have been made. I'd like to, my lord, please. Basically, the written statement, but for that, the plaint is also required.
Can you do one thing, please? Can you come with a compilation, plain written statement? Because I think it's very difficult to handle this record. Plain written statement issues, at least.
I'll do that.
The deposition and the evidence were given.
Yes, so far as this plain written statement.
Yes, it's in a bad shape.
It is plain. The parking plain written statement or written statement. It is a total statement. Written statement, deposition আছে আর ফাইনাল গুলো দিন না Track
So let me have it. I'll mark it.
একটা ডিপোজিট হ্যাঁ ওগুলো পড়ে ওগুলো নিচে রাখো The black mark is a
Yes.
number statement and the first one is the plain.
Kindly come to the plaint, my lord. First. Lordship will find, my lord, there are, my lord, 4 plaintiffs. And, my lord, there are 3 defendants. The first one, Mrs. Sharkar. The second defendant is Miss Sharkar, my lord, the mother and daughter. And then, my lord, our company. Now, may I place the plate? May I place it?
So just a minute. Yes, sir.
Kindly come to the plane.
Yes.
Well, Lordship will find, my lord, that there are three defendants. Basically, I am interested about, my lord, the first two defendants. Defendant number one is the mother and the defendant number two is the daughter. Now, as on date, my lord, the suit is being really contested by the defendant number two because, my lord, the defendant number one has settled.
Expired.
Yes. Now, kindly come to the pleadings. Premises number 215 and 217 Netaji Subhash Chandra Bose Road, Taliganj, situated outside the jurisdiction, were owned by Sri Shankarlal Sarkar since deceased. The said premises were at all material times and still are tenanted premises. The said premises are contiguous to each other and have since been amalgamated and cover a total area of 34 katas of land with building. Description is mentioned in a schedule being Annexure A. On 30th January 1987, Shankarlal Sarkar died intestate, leaving him surviving his widow, the defendant number one, and his only daughter, the defendant number two, as his heiress and legal representatives. Thus, the defendants number one and two have become absolute owners of the said premises. Plaintiffs carry on business jointly. The plaintiffs are in control and management of the defendant number three, and the plaintiffs number one and two are the directors thereof. The plaintiffs through the defendant number three carry on the business as developer of property. Next, paragraph 5. The defendants number 1 and 2 expressed their intention to develop the said premises, which could be done only after shifting the tenant. In or about first week of April 1987, several discussions and negotiations took place between the plaintiffs represented by the plaintiff number 1 and the defendants number 1 and 2. Ultimately, in July 1987, it was orally agreed by and between the plaintiffs and the defendants number 1 and 2, inter alia as follows. For the purpose of development, it will be advantageous to have the said two premises amalgamated and the amalgamated premises would be developed. The defendants number 1 and 2 will receive 25% of the covered area of the building to be constructed at the said premises, and in addition thereto, will receive total amount of rupees 11,31,500 as and by way of further consideration. All such payments will be made to the
So
defendant.
25% of the covered area,
Constructed, yes.
constructed area plus 11.31 something.
11.31 lakhs. All such payments will be made to the defendants number 1 and 2 through the defendant number 3. In consideration of the aforesaid, the defendants number 1 and 2 will transfer 75% of their ownership of the said premises in favor of the plaintiffs and will appoint the defendant number 3 as a contractor to construct a new building at the said premises as per building plan to be sanctioned by Calcutta Municipal Corporation. For the purpose of giving effect to the aforesaid overall agreement, separate agreements in writing for sale of 25% share in the said two premises to each of the plaintiffs number 1 and 2, and for sale of further 25% share of the said premises in favor of the plaintiff number 3 and 4 jointly will be executed by the defendants number 1 and 2. The contract for construction of the building at the said premises will be prepared and executed between the defendants number 1, 2 and 3. The total consideration amount payable in cash as aforesaid would be paid by the plaintiffs in portion of 1/3 for each of the plaintiffs number 1 and 2 and the plaintiffs number 3 and 4 jointly to the defendant number 3, who will accept the same for and on behalf of the defendants number 1 and 2. Then paragraph 7.
Just a minute, let me understand G first.
The total consideration amount payable in cash as aforesaid would be paid by the plaintiffs in portion of 1/3 for each of the plaintiffs number 1 and 2, that is 2/3, and the plaintiff number 3 and 4 jointly to the defendant number 3, who will accept the same for and on behalf of the defendants number 1 and 2.
and then will be repaid to defendant number 1 and 2.
I will show your lordship the valid relevant portions. Then kindly come to paragraph 7. In pursuance of the aforesaid agreement for sale and an agreement for construction were duly prepared, on 5th August 1987, the following agreements were executed by and between the parties here. First one, the agreement for development and construction of the building by the defendant number 3 was executed by and between the defendants number 1 and 2 on the one hand and the defendant number 3 on the other, providing therein payment of cost of construction at the specified rate. B. Agreement for sale of undivided 1/4 share of the defendants number 1 and 2 in premises number 217 Netaji Subhash Road by the defendants number 1 and 2 in favor of the plaintiff number 1 was executed by the said parties, showing consideration amount of rupees 5,98,500. C. The agreement for sale of undivided 1/4 share of the defendants number 1 and 2 in premises number 215 Netaji Subhash Chandra Bose Road, Taliganj, Calcutta by the defendants number 1 and 2 in favor of the plaintiff number 1 was executed by the said parties, showing consideration amount of rupees such and such. Agreement for sale of undivided 1/4 share in premises number 215 Netaji Subhash Road, Taliganj, Calcutta by the defendants number 1 and 2 in favor of the plaintiff number 2 was executed by the said parties, showing consideration amount of such and such. The agreement for sale of undivided 1/4 share in premises number 217 Netaji Subhash Road by defendants number 1 and 2 in favor of the plaintiff number 2 was executed by the said parties, showing consideration amount of such and such. Then agreement for sale of undivided 1/4 share of premises number 215 Netaji Subhash Road by the defendants number 1 and 2 in favor of the plaintiff number 3 was executed by the said parties, showing the consideration amount. Well, these are the particulars. I am not reading out these copies of the agreements. I shall show you lordship in due course.
Different deeds for different plaintiffs.
Yes.
What I find.
Different properties on the same.
No, 1/4, for example, first para B, agreement for sale 1/4 share in 217 in respect in favor of plaintiff number 1.
Yes.
Then para C, agreement for sale of undivided 1/4 share 1 and 2, 215, that is to plaintiff number 1.
Premises number 215.
215, yes. 215 to plaintiff number 1. Then 1/4 in respect of 217 to plaintiff number 2.
D is, my lord, 215.
D is
1/4
215
in 215
in favor of plaintiff number 2.
plaintiff number 2. Yes.
First 2 for plaintiff number 1.
Yes.
Second, D and E
Yes.
for plaintiff number 2.
That's true. That's true. And
Then
my lord,
plaintiff number 3.
F and G, plaintiff number 3 on the same day.
That means total 6 agreements are executed.
Yes. That is, my lord, in fact, my lord, the starting paragraph of paragraph 7. Then, my lord,
6 several agreements of sale.
Yes. Then, my lord, kindly come to paragraph 8. All the aforesaid 6 several agreements for sale were executed as part of overall common project of the development of the said 2 premises. 9. All the aforesaid 6 several agreements for sale contained identical terms and conditions, and some of them are set out herein below. I am omitting this for the time being, it's not required. But kindly come to, my lord, page 11. Pursuant to the said 6 agreement for sale, the plaintiffs paid earnest money to the defendants number 1 and 2 as follows, my lord. The particulars are given. Then 11. All the aforesaid payments of earnest money were made by 12 several bankers' check issued by Hong Kong Bank, all dated 4th August 1987. The said checks were received by the defendants number 1 and 2 at the office, my lord, of the solicitor within jurisdiction. Then 12. In respect of the development agreement, the defendant number 3 paid a sum of rupees 5,000 to each of the defendants number 1 and 2 on 7th August 1987 by banker's check issued by Hong Kong and Shanghai Bank. Then 13. In performance of the said agreement for sale, various steps were taken by the plaintiffs themselves and or through the defendant number 3, some of which are mentioned below. Then, my lord, what are the steps taken? The defendant number 3, for and on behalf of defendant number 1, duly took steps for mutation and recording the names of the defendants number 1 and 2 as owners in place and state of Shankarlal Sarkar in respect of premises number 215 and 217. The defendant number 3 obtained all the required forms, papers, affidavits duly signed and executed by the defendants number 1 and 2 and submitted the same before the Calcutta Municipal Corporation. Due to the effort of the defendants number 1 and 2, the name of, sorry, should be plaintiff. The names of the defendants number 1 and 2 were duly mutated and recorded as owners in respect of premises number 215 and 17 Netaji Subhash Road, which were also amalgamated. Then B, the plan for construction of multi-storied building at the said premises number 215 and 217 Netaji Subhash Road was prepared and upon approval and signature of the defendants number 1 and 2 were submitted to Calcutta Municipal Corporation at Calcutta within the aforesaid jurisdiction on 14th October 1988. Various negotiations were held with the tenants of the premises number 215 and 217 Netaji Subhash Chandra Bose Road outside the aforesaid jurisdiction for vacating the said premises, and costs incurred in respect thereof were borne by the plaintiff through the defendant number 3. The defendant number 3 duly deputed its engineer and workmen for making comprehensive cost estimation, for making alternative arrangement for shifting the tenants, and have made repairs also. Defendants number 1 and 2 executed and registered a power of attorney in favor of the defendant number 3 at Calcutta within the jurisdiction. Various steps from time to time were taken with the Calcutta Municipal Corporation for sanction of the plan. The defendant number 3 duly obtained the permission and clearance from Calcutta Improvement Trust, Fire Department, etc. at Calcutta within the aforesaid jurisdiction. The plan has been duly scrutinized by the department and found to be in accordance with the existing rules. However, before the plan could be finally approved by the building committee of the Calcutta Municipal Corporation, a change was made in the existing rules for sanction of building plan by the Calcutta Municipal Corporation, and certain new restrictions were put. On December 18, 1989, Section 398A was incorporated in the Calcutta Municipal Corporation Act 1980 by way of amendment. By reason thereof, all pending plans for construction of building of more than 18 meters height stood rejected. The building plan as submitted in respect of this 8 premises was for construction of a building of more than 18 meters in height. In the circumstances, a writ petition was filed by the defendants number 1 and 2 in this honorable court, challenging the virus of section 398A. This honorable court, by an order dated 7 September 1992, directed the Calcutta Municipal Corporation to grant sanction of the plan in accordance with the law within the period of 3 months from the date of communication of the order. In the meantime, in another case, Section 398 of the Calcutta Municipal Corporation Act has been declared as ultra vires by a judgment of the division bench of this honorable court dated 3rd March 1990. In the premises, the plaintiffs and the defendants were hopeful of getting the building plan as submitted to be sanctioned by the Calcutta Municipal Corporation. Calcutta Municipal Corporation preferred an appeal before the Honorable Supreme Court and obtained stay of the aforesaid judgment of the division bench of this honorable court. In the premises, the building plan as submitted in respect of the said premises was kept pending by Calcutta Municipal Corporation. The appeal before the Supreme Court was still pending. The plaintiff held discussions with the defendants number 1 and 2 in view of the aforesaid changed circumstances and to decide whether the parties should wait until further disposal of the appeal by the Honorable Supreme Court or submit a fresh building plan. In the meantime, a new building rule came into operation in or about 1993. Under the new building rules, the covered area of the proposed building would have been much less. Ultimately, in or about September 1993, it was decided by the plaintiffs and the defendants that the parties should wait till final disposal of the appeal before the Honorable Supreme Court, as it was likely the appeal to be disposed of by the Honorable Supreme Court expeditiously. The Honorable Supreme Court disposed of the said appeal by a judgment and set aside the judgment of the division bench of this Honorable Court and upheld the validity of Section 398A of the Calcutta Municipal Corporation Act. In these circumstances, it became necessary to submit a fresh building plan to be prepared in accordance with the new building rules.
Another matter has been called up.
I know, my lord, I am at great risk of keeping Mr. Dev keeping here,
Behind
my
your
lord,
back.
waiting. Keeping him waiting, my lord, is...
Your clerk is there. He just said. বাজে কথা বলছি না।
I really do not know what will happen to me, my lord, when I go back to the library. Whether I would be, my lord, able to sit in my chair or not, that is also in doubt. 7, sir. Paragraph 20. A fresh building plan was caused to be prepared through the defendant number 3 in accordance with the building rules in or about 15th May 1995. Thereafter, the plaintiffs approached the defendants number 1 and 2 for their signature and consent being owners of the said premises. At this stage, in or about 7th August 1995, the plaintiffs found that the relationship between the defendants number 1 and 2 had unfortunately deteriorated and they were not even on speaking terms, the mother and daughter, my lord. At one stage, the defendant number 1, by a letter dated 20th October 1995, asked the plaintiff to go ahead with the said project with the defendant number 2 alone, but later on changed her mind and by a letter dated 5th December 1995 expressed her intention not to proceed further with the said project for development and thereby for the first time on 5th December 1995 refused to abide by the said agreement for sale. Then, my lord, the usual paragraphs I am not reading out. Paragraph 22, that, my lord, the plaintiff has performed and has always been ready and willing. Paragraph 23, the plaintiff has applied to perform. Then 24, my lord, there exists no standard, etc. Now, my lord, kindly take up the written statement of the defendant number 2 that was flagged. Because today, my lord, the written statement of the defendant number 1 is
Not so relevant.
Only relevant, my lord, I would like to put it that way. Hey. You check. My lord, kindly take the written statement of the defendant number 2. With reference to paragraph 1 of the plaint, this defendant denies that premises number 215 and 217 were or are wholly tenanted premises as alleged or at all. The defendants and this defendant and defendant number 1 reside in the said premise. With reference to paragraph 2 of the plaint, this defendant denies that the total area of the said 2 premises is only 34 katas with building or that the said premises has been correctly described in the schedule to the plaint as alleged or at all. This defendant disputes the rest of the allegations. Statements made in paragraph 3 of the plaint are correct. 4. The defendant disputes the allegation made in paragraph 4 of the plaint and put the plaintiff to strict proof thereof. 5. With reference to paragraph 5 of the plaint, this defendant denies that she expressed any intention to develop the said premises or that the alleged development could be done only after shifting the tenants as alleged or at all. She signed the agreements. Then paragraph 6. With reference to paragraph 6 of the plaint, and various subparagraphs thereunder, this defendant denies that there was any discussion or negotiation in or about first week of April 1987 between any of the plaintiffs or the plaintiff number 1 or the defendant number 1 and herself, or that in July 1987 she orally agreed with the plaintiffs or the defendant number 1 to any of the alleged terms or conditions alleged in subparagraphs A to G as alleged or at all. Now, my lord, pausing here for a moment, Lordship will see, my lord, there is no prayer for cancellation of these documents. There is no prayer in the written statement of the defendant number 2 saying that this document should be delivered up and cancelled.
No counterclaim. Next day, Mr. Davies was smiling at me.
I am scared, my lord.
It is very dangerous for me also.
Yes, absolutely. Whatever I said, that's correct. Correct fact.
Heard Mr. Mitro, the learned senior counsel, in part. 11 February is okay?
Oh, some day thereafter.
Subsequent dates.
Yes.
Okay. 18 February? 18 February for further argument.
I will bless.
এটা এইভাবে রাখো। No, it is dangerous for me, both of us. You are at your back, but I am facing you.
Then I will not appeal. All I require, my lord, all my seniors' blessings. This much I give. He should change his name. Yes, Mr. Binoy Day.
Item 23.
My lord, item 23, my lord, I leave to appear virtually. GA3 is my application appear for the plaintiff.
GA3 and GA4.
GA3.
What is GA3 and GA4? Two are there.
GA4. আমারটা
Oh, sorry. Four.
So GA3 be taken up first.
Here I want to produce the original death certificate. It fell from your my lord that the original death certificate is not marked as an exhibit. It was fixed for argument. So this application.
Just a minute, let me go through these applications.
বাইরে তো বুঝতে পারছি কোর্টে গেছে মনে হচ্ছে কোন কোর্ট সুপ্রিম কোর্ট মনে হচ্ছে
Yes, this is an application for allowing photocopy.
The original has to be death certificate. The
No, this is for pension, PPO.
Yes, that's my
application. That is done. That is done. That is over. That is
one by one. I will come one by one. This is the earlier application.
My lord.
This application has been filed by me, Your Lordship. When Your Lordship, the witness was, Your Lordship was on the box.
I'm allowing this application.
Maybe disposed of, Your Lordship, that.
GA3 of 24, one by one. I will take up your case.
Right.
File is filed. Praying for allowing the defendant to adduce in evidence copy of pension payment order since the original is in the custody of the government. Mr. Mitro, the learned counsel appearing for the plaintiff, are you objecting to? Not raise any objection.
Yes, yes.
Full stop. Since affidavit of in opposition is not filed, the allegations are not deemed to be admitted. Accordingly, where is master summons? Prayer A of the master summons is allowed. The defendant is given liberty to adduce in evidence authenticated copy of the pension payment order mentioned in the application. GA 3 of 24 stands disposed of.
Yes,
Now
this is already, yes, but this is already allowed because the suit is for argument.
GF4.
Yeah, GF4 is my application to bring and record the original death certificate.
Where is the original death certificate?
He's handing over to the court. It's been marked as an exhibit because the arguments are going on in the suit.
The Lordship was of the view that this particular original death certificate has
GA4 of 25 is filed by the plaintiff for marking the original death certificate and admitting the same evidence. Now, for admitting the original death certificate as evidence and marking the same. Let GA4 of 25 be allowed. Death certificate issued by the Register birth and death, Barasat municipality, be admitted in evidence and be marked accordingly as
last exhibit number.
What is this plaintiff's exhibit?
Yes, plaintiff's exhibit.
মার্কিং হয়নি
কি বলছে তোমাদের লিস্টে লেখা হয় এই তো plaintiff's last
It will be D. Exhibit D. GF
4 may be allowed.
4 of 2025 stands disposed of accordingly.
Yes.
Lordship will give a date for argument. I will commence the argument.
Argument is yet to be commenced.
Yes, Your Lordship.
I have already done one day when it fell from your Lordship that the death certificate is not marked. Any
issues were recast.
Yes, yes.
Issues were recast.
Lordship has recasted the issue.
Fix.
Whether I start or the defendant start, whoever starts.
Defendant will start.
I'll start.
Yeah, defendant will start.
You adduced evidence last.
Yes, sir, last year.
Yes.
এটা তো যে কোনো দিন হবে আর্গুমেন্ট তো যে কোনো 19th February for argument.
19th February at 2 o'clock.
My lord.
I will not hear you. You are a mischievous person.
How can you say this, Lord? I will not utter a single word.
No, words are not enough. Gestures are more important, more powerful.
Mr. Mitro, your matter has been called on, and he will be speaking, and he will realize, and he will offer me tea Millard when I go to Balaji. But what Lordship has said, I'm scared of you. That Millard is troublesome for me. I'm grateful.
Anyway,
24 and 25.
Witness is there? Yes.
This is what we have in the profession, Millard. A little bit of learning, but enjoyment for me. Absolutely.
Commercial break.
Commercial. Millard, I'm late, my mistake.
Cross or chief?
Cross.
No, what about these applications?
I do not believe any applications are pending at the instant moment.
1 of 95, 4 of 96. Let me call for a report.
Lordship.
Possibly I have called for a
Most likely those are
All are
disposed of or become infructuous.
or I can do one thing at the time of disposal of the suit, I can dispose it all.
Lordship.
But one current application GA 23 of 24.
Lordship, this was the application filed by the plaintiff, gone up in appeal. So thereafter, this examination was conducted in view of the division bench's judgment. But your Lordship will call for a report. It will be better because your Lordship, since it's an old suit of 1992.
No, this application 23 of 24 should be deemed to be disposed of then.
Not with the appeal court's order. And in
Lordship.
terms of the appeal court's order, Honorable Lordship is hearing this, where the appeal court has categorically said, presided over by Justice Tandon Miller, that this has to be done by
Trial on
trial and
evidence.
evidence. And certain documents are required to be considered.
What is 23 of 24?
And their application.
Lordship, my
under order
application.
Preliminary hearing.
Lordship,
certain
my
documents. Yes, you can tell.
So my application, my learned friend had, the defendant had filed an application under Order 7, Rule 11 for rejection of the plaint on the ground that the agreement for sale could not have been entered into since Mrs. Helen Wilson was a foreign national. So the Order 7, Rule 11 was dismissed. My learned friends had preferred an appeal therefrom, wherein Justice Mukherjee, sitting in the division bench, was pleased to observe that since the suit is old and this is the limited issue, preliminary issue which needs to be decided, therefore there should be a trial on evidence only limited to such issue, to this preliminary issue. So, Your Lordship, that came back in the trial court, and when Your Lordship, thereafter we filed this application J23 of 2024, alleging that this is a pure issue of law, and therefore no evidence is required to be adduced in such matters to decide this preliminary issue. Which the learned single judge held against us. We went up in appeal, which the division bench also confirmed that since it is an old suit, only to the limited to this preliminary issue, evidence may be adduced, pursuant to which Your Lordship is hearing this, taking this evidence.
So it is deemed to be disposed of.
Lordship.
Appeal court orderটা কোথায়?
But Your Lordship, I will humbly beseech Your Lordship to call for a report because it will be
May
beneficial
not
for
reflect
the
everything.
Lordship. Because it will be
Because
beneficial
if
for
it
the
is deemed to be
parties.
disposed of, that will not be reflected in the
Lordship, then we
report.
will assist Your Lordship on that. But because Your Lordship, I'll be very candid since this is a
তাহলে একটা কথা
1992
লিখে
suit.
রাখো। The learned registrar original site shall furnish a report on pendency status of the applications.
Grateful, Lordship. Because Your Lordship, we are also new to the matter comparatively. Grateful.
The report shall be submitted before this court on or before the returnable date. Yes.
Question 36. Please see the question and the answer. This was in chief. Yes. Is this your legal opinion? You are an advocate. Section 30, question answer to question 36. You said that the defendant has no idea to obtain permission from RBI. Agreement for sale is a required document that needs to be submitted and annexed with the IPI.
Be slow. Be slow.
I'm sorry. No, because I'm reading out so.
Idea to obtain permission.
The defendant has no idea. Stop. To obtain permission from RBI, agreement of sale is a required document that needs to be submitted and annexed with the IPI2 form. Is this your legal opinion?
This is as per the IPI2 form.
So this is not to your knowledge.
This is to my knowledge.
Very good. Now, exhibit 6 আছে একটা বই। Exhibit 6 একটা বই আছে। একটাই বই আছে। Exhibit A বলো। Exhibit A নয় তো evidence এ গেছে as exhibit ভিতরে যাবে এটা যাবে আচ্ছা আচ্ছা এ ওকে ওকে আমাদের 1 2 3 হ্যাঁ এই kindly come to page 1.240 খুলে দেবেন Section 31. Page 1.240, section 31. Can you read out the section 31, please?
These are all legal questions. These are
Well,
all
since
legal
he
questions.
has
Provision of a
given a
section.
legal opinion, what has
Ask his opinion. What do you think of so and so?
Yes, very well.
Not to read out these sections.
Now, in section
Because his opinion is its own question. It's a question of fact and his own personal issue.
in section 31, we will find this portion.
Put the
Transfer.
question in a different way. Do you think, in your opinion,
Yes.
whether this agreement for sale is barred by law?
Yes. Or
In this manner, I'm just suggesting.
So, transfer or dispose of by sale. Got it? Transfer or dispose of, section 31, within section 31, about 2-3 lines below. Transfer or dispose of by sale, mortgage, lease, gift, settlement, or otherwise. Now, this word otherwise, I am suggesting you that otherwise includes an agreement for sale, which is other than sale, mortgage, lease, gift, or settlement. Do you agree?
No.
Can you give me the book? On the right hand side, you see the chapter 3, what it provides, what is written there.
It's written forms prescribed.
It is chapter 3 of this book.
It's written forms prescribed by Reserve Bank.
Now come to page 3.172. I think there is a flap. 3.172. What is this form?
IPI 2.
This is the form you referred in your evidence?
Yes.
Now, this form is a form by Reserve Bank of India and not part of Foreign Exchange Regulation Act.
What is your opinion on this point? He can give his opinion, not general legal opinion.
This form IPI 2 is a form suggested by Reserve Bank of India and is not a part of Foreign Exchange Regulation Act.
What is your opinion on this issue?
It is part of FERA. It is written application for
Again,
permission.
come to the chapter heading.
According to you, it is part of FERA.
Yes.
Look at the chapter heading. It says form suggested by RBI.
I do not understand.
Mr. Shortcut, this is a question of law.
It is a question of
His opinion is a
interpretation.
question of fact. That can be given.
Okay.
And you make argument at the time. Final argument, you say these things.
I am showing you.
FERA. FERA. Answer yes.
I am showing you Exchange Control Manual of Reserve Bank of India, chapter 11. Kindly look at paragraph 11E.3. Do you find IPI 2 form is mentioned there?
Yes.
Now, therefore, I suggest to you that form IPI 2 is a part of Exchange Control Manual of Reserve Bank of India and not part of Foreign Exchange Regulation Act.
What is your opinion on this?
I disagree. It is part of FERA.
According to say,
According
whether this is your opinion or this is the law, how would you say that?
According to me, IPI 2
You cannot
is
set out the law. You can say your opinion.
part of FERA.
Now, witness, I'm showing you Exchange Control Manual, Chapter 1. The object of the Exchange Control Manual under which IPI 2 is made. Kindly go through the object.
They are all matters of record, all law, legal issues.
Legal issue.
What will he do?
In the form of his opinion.
And he has not come as a legal expert.
Not legal argument.
expertise. What will
He will
come
not
on his
set out the
evidence? All he has done,
I'm avoiding legal things.
all he has done
Just
is exhibited that book because that book contains the original form.
Right.
That's all.
He cannot argue that. Put something in your
cannot
mind which
put,
legal
Very much. I'll
interpretation
put that way.
question.
I appreciate my learned friend's concern. I will. Have you gone through?
No, I'm going through.
Yes. I suggest to you that Exchange Control Manual or IPI 2 is a general mere guideline for authorized dealers and do not have force of law.
How do I object to this question? Force of law, how will he know? Absolutely a legal
Ask the question in a different way.
Very well. I suggest to you that IPI 1-2 form is not a statutory form, it's a mere guideline.
That is a question of law. That will be
Very well.
decided.
Very well, madam. Then I'll skip over, madam. Now, kindly come to question 37. Question 37 is dated 3rd December 24. Have you gone through? Now, your answer is that Mrs. Helen Wilson, during her lifetime, did not take the point of non-availability of permission from RBI.
Yes.
Kindly look at amended plaint at the beginning. Amended written statement. Kindly look at paragraph 14C. हाथे लिखा amendment है. Kindly look at paragraph 14C, that this point was squarely taken in the amended written statement filed by Mrs. Helen Wilson.
As per the records.
Therefore, on the last occasion, you have made an incorrect statement.
No, my statement was when we entered into the agreement for sale of the premises, she did not inform her nationality. Later on, when we came to know that she was a British national, my father and then later our advocates asked for the RBI permission under FERA. Then as well, she did not give a definite answer and said, we'll provide all the documents. So my answer is correct that she did not use this even in her cancellation letter addressed to us. She never mentioned about the RBI permission.
Kindly show question 37 again. Now read it again.
Yes.
You have read it. It say, during her lifetime, ever take the point.
This was my misunderstanding the question. I thought it was before filing of the suit.
Right. Thank you. Now come to question 68.
Yes.
Have you gone through question 68?
Yes.
Now, the agreement dated February 2nd, 1989, of which specific performance is sought, was cancelled by Mrs.
Of the specific
Performance is sought was cancelled by Mrs. Helen Wilson. Now showing in the plaint.
What was question?
Questions 60. I've not asked the question yet.
Oh.
I've just made half of the question. Then question, the plaint is shown. Can you look at the prayer portion of the plaint? Have you shown the prayer portion of the plaint? Have you made any prayer? Have the plaintiff made any prayer for declaration that the cancellation was bad or not binding on the plaintiff?
It is as per the records.
It is there or not?
As per the records.
Are you aware of any such record?
I'll go through.
Please. Right.
Yes, okay. No.
I'm suggesting to you that agreement cancel is non-existent in law, and such non-existent agreement cannot be enforced by the plaintiff.
I'm objecting to this line of questioning. These are points of law that my learned friend will argue.
Okay, okay.
My witness will say.
Well, only thing is at the time arguing, they say you are not taking the cross, carapiet and all these
No,
things.
you have asked whether you are aware of this.
Yes.
That question is also pointed out.
Yes.
So no,
No.
question of law. Are you aware of the fact whether any suit for cancellation of instrument was filed or not?
No.
That is when Helen Wilson cancelled the deed agreement for sale. Did you challenge that in any court of law?
My lord, she wrote a letter saying she wants to cancel the sale of agreement. After that, no action was taken, nor the earnest money was refunded by her.
Did you file any suit?
And we replied.
Did you file any suit? It is Jabe. We replied, but we did not file any suit.
I'm suggesting to you that without such declaration, this suit is not maintainable.
That is legal opinion.
Wait. Now, I'm suggesting to you that section 31 read with 47 and 50, this agreement is illegal and barred by law.
I need to read the other sections.
What do you think?
Question of law.
Not necessary.
That is the question of that's a matter of argument.
All I have to keep a touch only. Otherwise, Lordship knows. Other side will jump.
Do you think the suit is barred?
No.
That's all. His thought is a question of fact.
Now, kindly look agreement that happened. Exhibit. Exhibit 3. Exhibit 3. Is this document a registered document?
May I object to this line of questioning? I should have stood up earlier. Lord, kindly appreciate that the exercise currently being done is on the preliminary issue.
The suit not maintainable.
Yes, it is only on the ground of Reserve Bank of India.
It's been maintainable on 10 grounds. I'm
I'm sorry to say, I'm very sorry to
Let this
say that
question
is
be
not
asked.
the ground at all.
I understand. Let this question be
This
because
is not
also,
a general roving inquiry whether the suit is maintainable or not.
right.
Only issue.
But this is a question. This can become because Reserve Bank order or FERA, all these things are related to agreement.
He is trying, my learned, if the witness goes out, I will explain what he's trying to say. The suit is otherwise not maintainable.
That point
because
will
of
not be considered.
stamp duty and all.
Obviously, that point will not be considered. That's why
So why these questions?
Very difficult to maintain a line between this preliminary point and end point.
One has to, because it's only the cross-examination and chief is
this question will go, but
limited to
this
the
question
point
will
of Reserve Bank of India. FERA and FEMA.
Yes.
Is this agreement registered?
No, as it was not mandatory that time.
Is it properly stamped?
That is not question of him. You know the procedure? That will, and at that time you did not.
Well, let my junior take some suggestion.
It's difficult to draw a line, but is absolutely correct. It's this much and no farther.
And Mr. Sharkar, at this stage, you cannot say it is not properly stamped. You have lost that right. Under section 38, you have lost that right. Once it is admitted, unstamped document is.
After witness goes down, we will discuss that.
That's a question of argument.
Mr. Witness, is your mother alive?
No.
Sorry. Can you tell this honorable court when was she born?
When was she born?
Year?
Date of birth.
Date of birth?
4 June 1951.
Thank you. And what's your date of birth?
27/10/1985.
27/10.
1985.
And when did you go to school first?
When I was
Mr. Dev, you are not audible properly.
Oh, I'm sorry. When did you go to school first?
when I was approximately 3 years old.
Witness, একবার ওই কাগজটা দেখ। I'm showing you a document being Exhibit 6. Have a look at this document. Tell this honorable court. What is this document about? The application stuff. Exhibit 6 tag button. 6. I can show it from my. Okay. So only what is this document about? Sit down here. Just have a go. Kindly go through this document and tell this honorable court what is this document about. Okay, put exhibit till that. Exhibit 6 खुलेगा, page 63 क्या है? 63 to 66.
Yeah.
What
Question.
What?
Oh,
I
what is the question? Sorry.
What is this document about?
This is Form IPI 1, application for permission under Section 31, para, to acquire and hold immovable property in India.
Who had made this application? As per this document?
As per this document, Helen Wilson.
Are you aware of Section 31? Yeah. Very good. Yes.
Yes.
Witness, I put it to you that the agreement for sale dated 2nd January 1989 is barred by Section 31 of PERA. That's a suggestion. You may agree, you may
I disagree.
that the agreement for sale dated 2nd January 1989 is barred by Section 31 of PERA. Witness, I further put it to you that the instant suit is barred by law.
Disagree.
Witness, I also suggest to you that the agreement for sale dated 2nd January 1989 is not enforceable in law.
Disagree.
As the same is illegal.
I disagree.
Very good. Witness, I put it to you that you have no personal knowledge about any of the facts that you had stated or deposed during your entire examination, and everything is based on hearsay evidence.
I disagree.
Very well. Witness, I put it to you that the reliefs claimed in the instant suit cannot be granted in view of bar of Section 31 of Foreign Exchange Regulation Act.
I disagree.
That's all.
Cross-examination is over.
Yes. Now, let
PW1, PW2.
PW2.
PW2 is cross-examined in full and discharged. Fix and so for further witness action.
He has a witness.
We don't have any other witness.
Yeah, nobody has any witness.
For argument.
my lord.
Their point, my lord, let them start.
Yes, that is.
Witness action in default argument.
No, there is no witness. There is no witness.
For argument, लिखे दाओ. As the learned counsel for the defendant, counsels for the defendant submitted, they have no witness to examine. Date कब देबे?
Well, can it be little early? So because we'll forget now everything fresh in mind.
I can return it in the
No, for us, man, for me.
12 is okay?
It's fine.
12th February.
I will not say anything. Great.
I am thinking about one point of law raised by Mr. Ghosh.
That
Ask him.
Outside court, my lord. Very good.
There's one,
That my lord has indicated from a long time.
one judgment is there. I just found it. Justice Sanjeev Banerjee's judgment.
Lordship.
I know. But that has been upset by the division bench. Possibly.
Still, there is Supreme Court judgment.
On that point, we'll discuss.
Provided professional fees are paid to you or to him.
Extracted in a different form.
I will be learning from him. So how can I expect fees from him?
Order 7, Rule 11, F.
F. Very well. Grateful, my lord.
26.
My lord, 26 I appear on behalf of the plaintiffs. Item number 26, my lord.
Yes.
This is living in Seattle and an application has to be made seeking leave of the Honorable Court to examine the witness on through video conferencing, my lord.
All right.
My lord, I seek some time to make that application, my lord.
On prayer of the learned counsel for plaintiff.
My lord.
Who is the defendant?
My lord, defendant is not appearing in this matter for a long time, though they have filed written statement, but for the
Plaintiff.
last several dates they have not appeared.
This action is adjourned to, when will you be able to come?
My lord, I am seeking 2 months time to file the application because that application has to be affirmed and apostilled through the embassy, my lord. That will take some time.
17th March.
My lord, grateful, my lord.
Item 27.
Company matters may not be taken up today. Today there is a resolution of 3:30. But one thing, let me finish this matter first. Yes. 27.
Item 27.
দেখি অর্ডার শিটটা কি আছে?
Indian ball bearing stores.
Sole defendant expired. None appears. Adjourned to 7th February.
28.
Well, I am for the plaintiff. Witness action to be done, my lord. My witness is present. I am also present with the original document, and of course, few are my secondary evidence. So,
Is it a commercial matter?
No, Lordship, it's not a commercial. It's a
CS.com, then why CS.com?
some error in the publication
দেখো
of
তো।
the list.
Oh, it was transferred to commercial division wrongly, possibly.
Cannot. It's a defamation matter.
No. It was transferred to commercial division wrongly, then once again retransferred to ordinary division. So that old commercial number is retained. Yes.
Yes. Anyone appearing for the
Yes. No, last time I already took the oath.
What is your name, sir?
Ian Craignagle. IAN. CRAIG.
Who is Justin Conrad Nagel?
Justice Conrad Legan. His brother.
Nagel. NAGLE. GLE.
Laneটা দেখি একটু। You are Ian Craig Nagel.
Yes.
Plaintiff number 2.
Yes.
একটা করে document. আরেকটা কপি করো।
Though in the original side, we do not make a affidavit in chief.
No, that's in commercial division.
That's in commercial division. But in this case, I have made one. Your lordship takes it, then it can take some.
Ask questions.
Document number 1.
Who is the defendant? Ex parte?
No, they were appearing. Today they have, I don't know why they have.
Where they are?
Know why they are. The last day they appeared.
We have only 5 minutes to ask.
Lordship, then let me ask 2, 3.
Yes.
Mr. Nagal, kindly tell my lord how you are acquainted with this case.
Your Lordship, I am one of the partners of the firm.
Which firm?
Peace Haven.
Peace Haven.
Yeah, I'm one of the partners. There are 2 other partners as well.
Kindly tell my lord, who are the 2 other partners in them?
One of them is Justin Conrad Nagel, and one of them is Brett Alistair Nagel.
Are we related?
We all 3 are brothers.
And the other is?
Brett, B-R-E-T-T.
Daddy?
T-T. Alistair, A-L-A-S-T-A-I-R.
Three brothers.
Can you tell in a very precise way what is the suit all about and why did you file this suit before this honorable court?
So, Your Lordship, the firm that we run, we were a false complaint was made to the Kolkata Municipal Corporation.
Be slow.
A complaint was made to the Kolkata Municipal Corporation alleging that our firm was causing pollution.
Which was causing pollution?
Our firm was causing pollution. And the gentleman who has sent the mass complaint his name is Mr. Sanovar Ali Malik.
Check the spelling.
Wait, defendant number 1.
So once he has done this, they have the Kolkata Municipal Corporation have cancelled our license.
Had cancelled.
And this is not the first occasion that he has done this. This is the 3rd occasion that he has done this.
This is 3rd time the defendant number 1 behaved in this manner and lodged complaint.
Yes. Due to this, our company has been closed for the last 6 years since the Kolkata Municipal Corporation have refused to give us the license, for which there is a writ
Yes.
For which there is a writ that is pending also in this honorable court.
Mr. Nagal, kindly apprise the honorable court. What are the unauthorized, biased, motivated campaigning is made by the defendants?
Sorry.
What campaigns defendant made against you?
Okay, so the last 3 occasions, he has done the same thing. He has.
What campaigns? What they say about you?
Basically, they are saying that we are causing pollution. People are getting sick. We are causing diseases like tuberculosis and AIDS and so on and so forth. And because of that, we should be shut down.
This much today. PW1 is examined in chief in part. Further examination in chief is deferred to 19th February. 19th February is okay? One matter I fixed for judgment, reserved for judgment. So I found, as per the rule, you said the assets are nil, but one auditor's report is to be certificate is to be filed. That I found in the rule for winding up. After winding up auditor's report, then court will pass order for resolution. You check the rule.
So the prayer was also made in the application. The prayer, I believe, my lord.
Auditor's report.
Yes, my lord.
Let it come tomorrow.
Yes.
I'll pass that order then.